Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 21-3074, United States of America versus Louis A. Wilson, also known as Spuds, appellant. Mr. Shelley for the appellant, Mr. Siebel for the appellant.
Good morning.
Good morning, and may it please the court. I'm Anthony Shelley, here as the court-appointed pro bono counsel for appellant Louis Wilson.
Welcome.
And I have reserved 2 minutes of my time for rebuttal. In its most recent briefing order, the court asked the parties to focus on first a procedural issue about exhaustion, and then a set of substantive questions regarding whether and to what extent a change in sentencing law can be considered in the context of a motion for release under Section 3582C1A. On this procedural issue first, the court precisely asked whether the exhaustion requirement in the statute is jurisdictional. All parties agree that it is not, and unless the court wishes to hear further about that argument on the non-jurisdictional nature, I'd like to turn to the related matter raised here by the government of whether the exhaustion rule, even as a non-jurisdictional rule, is so mandatory that it forecloses the court from getting to the substantive issues the court has asked the parties to brief. The courts would be foreclosed from hearing that substantive issue only if Section 3582C1A mandated issue exhaustion. For Wilson plainly did file an administrative request for release with his warden. He just did not present one of the particular issues, a change in sentencing law, to the warden. As we noted in our brief, the statute says nothing about issue exhaustion, but indicates only that he make a request to the warden for release, which he did. And the text should end the matter. Congress knew how to say things with more detail because it did in other parts of the exhaustion sentence by saying the other alternative requires fully appealing through the administrative process. This one says only you needed to file a request and wait 30 days. It doesn't say, for instance, that the request needs to be put in detail, the request needs to raise certain issues. It just simply says you need to file a request. And that makes sense because Congress was somewhat upset with the Bureau of Prisons in the first place for not properly administering the statute, and therefore I think gave prisoners a relatively easy route to present a request to the warden, and then if it was unsuccessful, wait 30 days from when the request was filed and go immediately to court.
But generally when people are filing claims, the person on the other side of the claim, whether it be complaint or claim, has the opportunity to respond. And so what about that opportunity of kind of hiding the ball or sandbagging, later on, not to suggest that happened here, sure. But the whole point is to put the person on notice.
But the government from the beginning has been responsible for investigating requests for compassionate release. When the statute was originally enacted in 1984, it had no exhaustion requirement at all. The government, on its own motion, had to investigate a prisoner and bring something to court. So all the exhaustion requirement here is doing is saying, Bureau of Prisons, warden, I'm here and I shouldn't be here. You need to investigate this and I need to be released early. And in fact, the Bureau of Prisons has a full list of considerations that the agency should go through whenever it receives a request, irrespective of what's raised by the particular prisoner.
And do you believe that the government waived that anyway?
I do. I do believe the government waived it because the government insisted on getting to the issue in its briefing in the district court. It wanted to get to, I think it wanted a dismissal of prejudice of Mr. Wilson's claim for compassionate release. And in addition, I think they wanted the district court to rule on the weighty legal issue of whether a change in sentencing law can be considered in a compassionate release case. And so it charged on to get to those issues. But it only, in arguing, it only raised the legal question of Mr. Wilson, whether the statute forecloses consideration altogether of a change in sentencing. The government really doesn't have any answer to the statute. our arguments based on the statute or the regulations, or even the Sims case or the Carr case, except to say, well, the Seventh Circuit already held on this, that there is issue exhaustion in the Williams case, but indeed several district courts have since then rejected the Seventh Circuit case, and the Seventh Circuit relied on some regulations from the PLRA context, Prison Litigation Reform Act context, that actually do say specifically you must raise all issues. But in this context, there is no requirement in the regulations or the statute that even mentions the word issue. So we would, our belief is that Mr. Wilson needed simply to file a request on the forms provided by the BOP, which he did, and he checked the boxes on there that he was allowed to check. There was no box on there to say change in sentencing law, and the form says you can't alter it or it won't be accepted. He did all that was necessary for him to do.
And the court did consider the other issues.
Absolutely, it did. The court did and didn't weight any exhaustion argument against him. On the substantive question, the court asked whether a change in sentencing law can constitute an extraordinary and compelling reason for release, and the court seemingly asked this question because the government's sole argument below and here has been that as a matter of law, district court is foreclosed by the statute from considering a change in sentencing law. This court has no precedent on that topic, and so it somewhat writes on a clean slate in a sense from this circuit's perspective, but notably there's a deep split in the circuits on this issue elsewhere. But the most compelling case is the Chen case from the Ninth Circuit that was issued just 2 weeks ago and has been brought to the court's attention this week in a 28J letter filed by the government, and then a response that we filed on Tuesday afternoon. The Ninth Circuit had no precedent on this topic, reviewed what all the other circuits had on the topic, and it had the benefit of the Supreme Court's Concepcion decision. The other circuits didn't have Concepcion, and the Ninth Circuit said, based on looking at all the other circuits and based on Concepcion, the text controls, and the text does not prohibit raising a change in sentencing law as an extraordinary and compelling reason, and that should be the end of it.
The question, though, counsel, isn't it, is what does that phrase mean? And you're arguing that it means that if Mr. Wilson were to be sentenced today, the law would be different. But the law hasn't changed to the extent that that change has not been made retroactive. So don't you have a threshold question here as to whether he has even suggested that there is a change in sentencing that the district court has to consider?
He has raised, thank you, Judge Rogers, for the question. Mr. Wilson, in his reply brief below at page 17, that's document 393, yes. In his first appellate memo, the one before I became counsel, at page 10, and then the government's first memo at note 3, filed March 3rd, all identify the change in sentencing law that Mr. Wilson believes changes the circumstances. And
I understand that, counsel. What I'm asking you is, what should this court hold?
This court should hold that any argument made by a prisoner can constitute extraordinary and compelling circumstances in the district court's discretion unless it's foreclosed by the Constitution or the statute.
Sorry, maybe I was unclear. Your client is relying on a change in sentencing. One way to read that is simply that the crimes for which he was convicted now face different mandatory minimums, or that the sentencing scope for the district court has changed. None of that is true in this case. So, as to your client, were his conviction to be reversed, his sentence would have to be based on the law as it was at the time he was convicted of committing the offenses. Is that not correct?
I don't think it's correct.
Even though the basis of the argument here is that were he to commit those crimes now and be convicted, he would be facing a different sentence. But that sentence has not been made retroactive. So on what basis would he be able to argue to the district court that in fact there has been a legal change in sentencing such that for the crimes of which he was convicted, he no longer can be, the district court would no longer have authority to impose the sentence of the length he currently faces?
The non-retroactivity of say, Booker and Apprendi, for instance, is not just positive, and the Supreme Court indicated that in Concepcion in dealing with another First Step Act provision, where it noted that under the other provisions for gaining immediate release, Mr. Concepcion was entitled to no relief. But the court noted, nonetheless, he could raise an argument that because of changes in the law that were non-retroactive, he would be treated differently today, and that's a fairness type of consideration that the court, and it's the district court in its discretion, can consider in determining early release. And here we would take that holding as the Chen court did exactly this, and the circuits that go our way have done, and said, even if the sentence had no legal problems back in 1997, if those same circumstances exist today and a 2022 sentencing judge were looking at this, and if the prisoner would get a significantly different sentence lower, the district court in its discretion can put that in the basket of considerations and decide if that, with all the others, is sufficient to allow Mr. Wilson early release.
So your argument is Concepcion plus a split in the circuits.
My argument is the text of the statute, that the extraordinary and compelling reasons has no limits other than rehabilitation alone cannot constitute an extraordinary and compelling reason. And that's what Chen, for instance, says. And all the circuits that go our way say the only statutory limitation is that rehabilitation alone cannot allow for early release.
So you agree, do you not, counsel, that there is a split in the circuits on this question? But
yes,
you're reading Concepcion to answer the question.
Yes, I'm reading that there was a split of about 5-5 at this point, with only this court not yet taking a position on it. I guess that would make it 6-5, one way or the other.
So my question, just so you're clear, is it an open question in this circuit? Or are you arguing that Concepcion controls? I think the best analysis is Chen, but also Judge Bates's analysis in a couple of decisions we cited, which is that it's an open question in this circuit, but given Concepcion, the necessary answer from the analogous situation in Concepcion is that anything not forbidden by the Constitution or the statute can be taken up by the district court as an extraordinary compelling reason, and the district court did not take this up. Even though Mr. Wilson raised it, the district court didn't take it up because it thought it was foreclosed on the face of the statute, because the change that he argues concerning Booker and Apprendi was non-retroactive. Concepcion pushes that to the side and says, just because something is non-retroactive doesn't mean you can't make a fairness argument that nonetheless you should be treated in the discretion of the district judge and get the benefit of the change in the law. So do you read that as dictum or an actual holding?
Well, it's holding with respect to the First Step Act provision at issue in Concepcion. It's not dictum at all. It's holding. The issue is, because this involves a different section of the First Step Act, should we do what the Seventh Circuit did and said, well, that's a different part of the statute, so let's not consider it at all. Judge Bates said the opposite. Chen says the opposite. And actually, when you go to this court's decision in United States versus Long, the court there, very recently involving this provision of the First Step Act, said the others look very much like this part of the First Step Act, so we're going to borrow the case law from over there for this one. And that's what we would say you should do here. Concepcion does not involve this particular section of the First Step Act, but Concepcion has so much information properly stated that's helpful in our case that it really is, in my view, it's disingenuous of the other courts, for instance, the Seventh Circuit, to pretend that case is just very narrow and limited to its facts. If I could, I know I'm well over my time, but if I could just read one part of it. The very first section of analysis from Concepcion says, and this is at page 2398, the Supreme Court site. From the beginning of the Republic, federal judges were entrusted with wide sentencing discretion. Federal courts historically have exercised this broad discretion to consider all relevant information at an initial sentencing hearing consistent with their responsibility to sentence the whole person before them. That discretion also carries forward to later proceedings that may modify an original sentence. Such discretion is bounded only when Congress or the Constitution expressly limits the type of information a district court may consider in modifying a sentence. And Chen, Judge Bates, and the circuits that are on our side all take that, presciently, the circuits that reached it before Concepcion said exactly this as well, that the text of the statute has to foreclose consideration of changes in the law in order for it not to be considered, even if they're non-retroactive.
Just a couple follow-up questions. With respect to your argument on disparity, it appears that Mr. Wilson was just discussing that there were changes in average murder sentencings nationwide, like he didn't appear to point to something very specific about not a retroactive change, but about a change in the sentencing law.
Correct. When he talked about disparity in his own brief, he talked about studies and statistical analyses that showed that when a judge has discretion about a sentence, that the discretion had been exercised in recent times far differently than it was in 1997, so that there are now disparities in the exercise of the discretion. And because the Section 3553A factors use the word disparity, that was his point. But his change in the law argument is different. His change in the law argument is that the district court, Judge Norma Holloway Johnson, back in 1997, considered facts that were not in front of the jury and that were not found by the jury in connection with a particular crime she was sentencing him on. And she could do that at the time, but she couldn't do that now under Apprendi and Booker. His first-degree murder charge under a federal defense would have been under the federal statute would have been a second-degree sentence in his view. It's complicated, but he never got the chance to present this to the district court because she categorically held that changes in the law don't matter. Okay,
and I'm trying to get to the point that, in my opinion, it would be a floodgates argument if we just talked about disparity generally, like looking at stats and sentencing commission reports and things of that nature without a specific change in the law. Perhaps okay.
if you were to hold that changes in the way in judicial philosophy from 2022 compared to 1997 are sufficient to allow someone out of prison, if that was the only angle the prisoner had, that wouldn't seem to be extraordinary in the sense that it could be made by many people. But he raises a change in sentencing law argument based on Booker and Apprendi. He raises that disparity argument, but he also raises his health, his good conduct in prison, the fact that the victim's family also doesn't disfavor his release, COVID-19, and a variety of other factors.
Okay, and then to take that point further, are you agreeing that a change in the law alone is not sufficient for the change in sentencing, that it should come with other factors in consideration? I don't agree with that, but I don't think you need to reach that here because he has raised several other factors, his health, his age, his
his good behavior.
And why don't you agree that a change in the law alone is not sufficient?
Why? Because I think that the statute doesn't say that. The statute does not say a change in the law alone may not constitute an extraordinary and compelling reason. Unlike it does say it does say rehabilitation alone cannot be an extraordinary and compelling reason. And I could foresee a case where a person in their 20s, for instance, or 30s, like Mr. Wilson, was sentenced to life in prison, which can be a 70-year sentence potentially as a result. The person lives to their 90s.
Or the Fair Sentencing Act.
Correct.
Okay.
And if the law changed so that that person might get 20 years, a 50-year difference is a very unique situation for that person. Could be that sole factor could be extraordinary and compelling.
And then where is the resentencing occurring? Are we looking to First Step Act, or are we looking to 3553A factors?
So the court, the way the case law plays out currently, the court looks to 3582C1A to determine if there's an extraordinary and compelling reason for him to be out. And he would say the constellation of factors in his favor here, including the change in law, should allow him, does get him through the threshold of extraordinary and compelling reasons. And then the courts look at the factors under 3553A to determine how much the reduction should be. He would argue they all weigh in, all the considerations sort of meld together here, and he should, having served 20, 26, 27 years at this point and being no risk and being unhealthy, all the factors even under the 3553A move him down to release now.
And is there any reason that the court, based on this record, could not make the decision if we were to rule with you that the change in the law in consideration of some of your arguments was sufficient?
I don't think this court could make that decision because under Long and under Concepcion, it's the district court's discretion that needs to be exercised. And the after development of the argument, and the argument was not developed because the district court held that as a matter of law, it couldn't be raised. So what we'd have to, I don't think on this current record that's in this appeal, this court or even the district court could just answer the question right now. Instead, the district court would have to have further proceedings in which Mr. Wilson proved his claim that among all the different factors, they weigh in favor of his release.
Okay. Judge Rogers?
I have one other question then. Do you concede that harmless error applies?
I think harmless error applies in most, it does generally apply in appellate cases, but this isn't a harmless error. You can't even judge if it's harmless because the argument was never considered by the district court. And this court
what I'm getting at, counsel, is suppose we assume merit to Mr. Wilson's argument on that point. Could not this court still conclude that any error was harmless in light of the factors the district court did identify? In other words, what I'm getting at is there's still a lot of discretion among district court judges in sentencing. And the fact that a defendant is young at the time he commits his offenses is certainly no bar, as we know from even recent sentences, to the district court exercising its discretion to impose life or near life, given the defendant's age. So here, the district court had a very different take on the factors that your client did raise, or the client whose case you're amicus. So that's what I'm trying to understand. In other words, we take the length of sentence, all right? But the district court, who's an experienced district court judge, and in the state court as well, decided the heinous nature of these offenses and the factors raised. In the district court's view, did not present the type of case for which the statute was designed, and therefore denied relief.
My position is that the district court came to that conclusion without consideration of one of the factors on the merits that Mr. Wilson raises, and whether the district court, when considering the factors that she herself found were in favor of Mr. Wilson, plus this additional factor, which should be assumed, as you noted, Judge Rogers, for your question, should be assumed in his favor, whether all those factors could outweigh the, as you put it, the heinous nature of the crime. We don't know.
Did the district court not say that considering what he had presented and argued, that was simply not enough in the district court's view to allow the type of narrow relief that the statute contemplated? I mean, this is not, let's empty the prisons, but rather for particular defendants, either because of health or something like that, basically out of the defendant's control, there can be relief. But that is not this case, the district court found. I'm just trying to understand why this court is barred from affirming in those circumstances.
Because the district court, when it considered this argument, this change in sentencing law or disparity argument, said, I will not consider a change in sentencing law, except I will, in the factors analysis, look to the length of his sentence. And if he served about 95% of the sentence, maybe that would weigh in his favor.
So what I'm getting at is that a number of circuits have not read this law to bar consideration of the 553A factors at the first step. And why should we?
I don't think you should. I don't think you should. I think all the considerations need to be considered by the district judge. In fact, the statute says that the 3553A factors must be considered in addition to all the arguments raised by the applicant. And here, the district judge left one section out that Mr. Wilson raised, and we can't know the answer to how she would have reached this, what the conclusion she would have reached if instead of the lesser number of factors and considerations she considered whether the result would be exactly the same if she had this additional factor that she wrongly thought was off limits.
Well, that's what I'm getting at. I don't see her saying that. And is your critique really that the district court never expressly said, even considering a change in law, as Mr. Wilson argues? In my view, the factors do not balance ultimately in his favor.
But the factors need to be balanced by the district court, not respectfully, not the Court of Appeals. And Concepcion has.
I'm arguing in my question, what is it in the district court's opinion specifically that tells you that the district court never considered how a change in sentencing in the liberal way that we've been discussing it in your answers would entitle him to relief? As I read her opinion, she viewed his crimes as particularly heinous, and the mere fact of his health, she said that was not persuasive given he's been vaccinated and no one else at the facility has an infection. And, the mere fact of his health, she said that was not persuasive given he's been vaccinated and no one else at the facility has an infection. And, the mere fact of his health, she said that was not persuasive given he's been vaccinated and no one else at the facility has an infection. And, the mere fact of his health, she said that was not persuasive given he's been vaccinated and no one else at the facility has an infection. he hasn't really pointed to anything else.
So, Your Honor, so on page 6 of the district court's opinion,
Yep.
The lower court said the length of time served factor will be addressed in connection with consideration of the 3553A factors, as it does not in and of itself constitute an extraordinary and compelling circumstance. So at the gate, the judge said, in reality, I can't even get to the 3553A factors unless you prove extraordinary and compelling reasons, and your argument about change in the law or the amount of time you've served would be different now. That I can't even consider as extraordinary and compelling. That's what she held on page 6.
Why do we read the district court's opinion in that way to assume legal error?
Well, I think it's plain legal error. She thought, and this was the government's argument that she accepted, which is that a change in sentencing law cannot be part of the extraordinary and compelling reasons consideration. I think it's plain that.
Counsel, I understand you keep relying on the government, and if I were in your shoes, I would too. But this court is not bound by either counsel's view. And I'm trying to get you to look beyond at what in the district court opinion convinces you that A, she could not, in the first step, look at the 3553A factors in deciding that even if there had been a change in sentencing.
So I wouldn't disagree that if she had looked at his argument in connection with the factors, or in this part of her decision in the extraordinary and compelling reasons analysis, if she had looked at his change in sentencing law argument in either place, that might suffice. But when on page 6, she says, I'm not considering it here in the extraordinary and compelling reasons. And then when you get to the factors analysis, she doesn't consider it. For instance, on page 10 is where she gets to it. She doesn't consider it there either. She reads it not that a change in sentencing law can be considered. What she says is, I'll consider a length of sentencing argument if you've served the vast majority of your sentence, which is another argument, of course, but it's not the argument he made. So the district court,
why don't we take her at her word is what I'm getting at.
I wish you would, take her for her word, because I think she did.
You want to read her word in the most negative way is what I'm getting at. And she says, alone, it's not enough. So then she says, but I'm going to consider the factors and then I'll decide. I mean, I think she was clear about the argument Mr. Wilson was making about a change in sentencing law. She wasn't even getting into this sort of technical argument that were posed by my questions earlier.
Well, I guess would repeat my answer just to summarize it, which is that she rejected the idea that change in sentencing law can be an extraordinary and compelling reason. She did say she would consider.
Alone. That's all I'm getting at. Yeah.
Well, alone, she says that. But yes, alone, she says that. But she does then cite a District of Kansas case, which follows the circuits that are negative altogether. But she then doesn't consider it as part of the extraordinary and compelling reasons at all. So whether she thought it couldn't be alone or even in conjunction with the other considerations for extraordinary and compelling is obvious, because she didn't consider it there. When she gets to the factors, she doesn't consider it there either, because the only thing she considers there, she matches how much time is served against the life sentence that he was originally given. That's not his argument on the change in law. His argument is that he wouldn't have been given a life sentence in 2022 based on what happened during the trial. He would have been given 25 years.
Thank you. Sorry to belabor the questioning.
Of course.
Thank you. I'll still allow you to reserve 2 minutes in rebuttal.
Thank you, Your Honor.
Okay. And just so all parties will know, Judge Silberman will not be present today, but he'll be relying on the briefs, the record, and of course, the transcript of this proceeding. Thank you. Government?
May it please the court, David Sable on behalf of the United States. Good morning, Judge Childs and Judge Rogers. Judge Rogers is absolutely right that we should take Judge Pollard-Catelli at her word. She said, ECF 399, in her motion, denial of the motion to reconsider, that she had discussed in her earlier order Mr. Wilson's arguments that the sentence he received would be shorter if he were sentenced now, and how this should be considered by the court as an extraordinary and compelling circumstance. She considered it, and she made it very clear in the order that her legal ruling was that a non-retroactive change in sentencing law could not alone constitute an extraordinary and compelling circumstance, which is the view of not only 6 circuits, but also the 4 circuits that have said it can be considered in combination. There is only 1 circuit, the 4th, that has said it could be considered alone. So any error, if there was error, we don't think there was, would be harmless for the additional reason that although Mr. Wilson said, yes, I have these other reasons I want you to consider. I'm hypertensive. I have early stage kidney disease. The court found that they were all unsupported. So if all those decisions are unsupported, the only thing he's left with here on appeal is an unvarnished claim that I would be sentenced to a shorter sentence if I were resentenced now, which is not cognizable. Even if it were, and Judge Childs, you asked this question, I think Judge Rogers, you did as well. We didn't have the PSR at the time, but his claim is, as I understand it, an Apprendi claim. He was convicted of killing a federal witness in the first degree. He was also convicted of first degree murder while armed as a DC code offense, which codifies the common law. There's no Apprendi problem here. There is no change in sentencing law, and the statute, not Booker, not the guidelines, the statute still says that if he were resentenced today, he would get life or death. So I think we're here. I didn't do a very good job of briefing this, but if we're here for a defendant who's got no legs to stand on his change in sentencing claim. Now, so that's why I think the claim is, it would be harmless. I'm just touching briefly on the exhaustion of remedies before we get to the statutory threshold question. As the court knows, when we brief a motion, we brief a claim, we brief our procedural arguments, we brief our merits arguments. We don't want the judge to come back to us and say, Mr. Sable, we don't like your procedural arguments. How about another brief on the merits? We do it all at once. We're not waiving our procedural arguments when we do that. So we haven't waived. We asserted our exhaustion of remedies argument. It's a mandatory claims processing role. We're entitled to have a ruling on that. On the issue preclusion issue, the Seventh Circuit said that there's issue preclusion and distinguished the cases that that appellant is relying on. I'm not going to say any more about that. You can read the case. The Third Circuit, in an unpublished opinion, has followed it, and Judge Bates has followed it here in this court.
What about in Carr v. Saul, which is Supreme Court 2021, indicating that administrative exhaustion does not require exhaustion of every issue?
I'm sorry, what was that case again, Your Honor?
Carr v. Saul, S-A-U-L.
I haven't read that, Your Honor. I remember the Sims case is the case that I thought the appellant was relying on, and it was distinguished in Williams. So I would have to rely on that and get back. That may be in Williams, I'm not sure. Turning to the extraordinary and compelling reasons question. When Congress created this very narrow exception to the presumed finality of legally imposed judgment, it imposed statutory question of extraordinary and compelling reasons. It's a threshold question that calls upon this court, if you address it, to construe the statute. This is not a question of judicial discretion in sentencing. This is a question of what did Congress mean when it said extraordinary and compelling. What do we know about what's extraordinary? Well, first of all, we know that the Supreme Court has said it's the ordinary practice when a legally imposed sentence is imposed that it remain in effect. So a change in sentencing law is imposed ordinarily, affects defendants who've not yet been sentenced, is not applied to the sentence who've already been sentenced. That's the ordinary practice. So the ordinary practice cannot be extraordinary. The plain meaning of extraordinary cannot be applied to legally imposed And what we have here is an ordinary, legally imposed sentence. That's what a number of the circuits have said. And I think the best construction of this that I've read would be the Andrews case out of the Third Circuit. Second issue is that we do have guidance from the commission, and this court has said, well, that guidance is not binding. But even the circuits that have said that guidance is not binding have looked to it as a guide. Why? Because Congress doesn't legislate against a vacuum. Congress changed the law in 2018 and said, this is a law that's been in place for 40 years. The inmate can file a motion, not just the BOP. But it didn't change the exhaustion of remedies provision, and it didn't change the extraordinary and compelling reasons provision. And we know that, and it didn't say anything about creating this freewheeling sentencing mechanism. We know the guidance refers to health conditions, refers to age, it refers to risk, it refers to family circumstances. It gives no indication that there would be any change in sentencing law is cognizable. Congress never said anything about this. It doesn't make sense to think that when Congress amended the law in this small way in 2018, it was creating this huge change in what the statutory remedy was and said nothing about it. That's not the way Congress works. It doesn't hide the elephant in the mouse hole. Moreover, in that very statute in 2018, Congress said, hey, those crack sentencing guidelines, yeah, we're going to make those retroactive. But it didn't say anything about making any other sentencing changes retroactive. So it's an end run around congressional intent. It just doesn't make sense to construe extraordinary and compelling reasons in this circumstance as anything as encompassing the sentencing changes in sentencing law, which we don't even have here.
Well, then how do you read Concepcion?
Concepcion is a case where it was undisputed that Concepcion was eligible for sentencing. And so it was a question of what is the court's broad discretion in sentencing? And so Concepcion would be applicable, as a number of courts have said, if we were at the 35. If we're in 3553A land, yes, that's what we're talking about Concepcion. The court considers the entire person, can consider everything. That's where Concepcion is pertinent. Concepcion says nothing about what the statutory term extraordinary and compelling means. The holding of Concepcion pertains to a different statutory provision, and the dicta pertains to 3553A. It has nothing to do with the threshold question of what this term means. And there just isn't any reason to go out and say, well, this term means something completely different than what it has been interpreted by the agency and by the courts to mean for 40 years.
But is there any circumstance under which the government would accept that a change in sentencing law can be considered extraordinary and compelling?
It's a difficult question to answer.
Well, for example, when I mentioned earlier the Fair Sentencing Act,
Yes.
They changed the ratio from 100 to 1 to 18 to 1.
Yes.
Would that be considered something that, even if it were not retroactive, that a district court could consider?
It's tough to say. Certainly some of those cases have emotional appeal, but my answer would be twofold, Your Honor. First of all, Congress creates these narrow exceptions, and it didn't create one for these other reasons. It created it for some, but not for others. Maybe that's unfair, but that's what Congress did. And the second thing is, if there is such a case, this isn't the case. Mr. Wilson killed a federal witness and was convicted of first-degree murder while armed. There isn't an Apprendi problem. There isn't a Booker problem. There isn't a change in sentencing law here. And I think, Judge Childs, you were talking to counsel about, well, what about changes in sentencing philosophy? None of these cases, there are about 15, 16 cases in the various circuits. None of these cases say anything about changes in sentencing philosophy. They all involve changes in sentencing law that are non-retroactive, like stacked sentences is the most common one, or the change in underlying convictions, which renders somebody not a career offender if they were resentenced. So the ordinary, again, court's brief indulgence.
But you have a circuit split, so how do you suggest that that be handled?
Right. So 6 circuits have said changes in sentencing law cannot be considered at all. 2 of those circuits say so in part because they believe that the policy guidance is binding. So maybe an asterisk goes by 2, but it's 6, 2 is an asterisk. 4 say in combo with other factors, it's okay. And only one says as a freestanding basis for relief, that would be the 4th circuit, that it's okay. And that was a stacked sentence. Obviously, you've read those cases, you're going to read those cases, you're going to decide which are the most relevant cases. I think this court's well aware that for the first time in years, thankfully, the Sentencing Commission has a quorum. And if the Sentencing Commission has new guidance, then the guidance will, of course, be required because the statute does require consistency with applicable policy guidance. And so hopefully that will be the case. This is an issue that will not be around for a long time. But again, we do think that that policy guidance should be a guide for this court, and there's no indication that guidance would reach out into.
I still don't hear in your answer which way this circuit should go.
Oh, this circuit should absolutely say, I'm sorry, thank you, because my supervisor would surely kill me if I didn't answer that question. The answer is, of course, this circuit should say that changes in sentencing law are not cognizable, are not by themselves. The district court's opinion was, by itself, a change in sentencing law is not an extraordinary and compelling reason. It did not raise the question of in combination with other factors. So to affirm on this particular point, the court would be on the side of 10 circuits and only disagreeing with the 4th. That is the right view. If there are no further questions, we would ask that the judgment of the district court be affirmed.
Judge Rogers, do you have anything else?
Thank you. No.
Thank you.
Have a good day.
Your Honor, I just want to make a few points. Mr. Sable indicated that none of the other factors that Mr. Wilson raised were accepted by the district court so that he'd be standing alone on this change in sentencing law argument. That's demonstrably wrong. The district court did find he was overweight, did find that he was of advanced age where COVID could be a greater risk. It did find he had an exemplary prison record. It did find he had an exemplary work record. And so there are factors when added to a change in sentencing law make this a multifaceted case as opposed to one where he's relying solely on a change in sentencing law. Mr. Sable also now gets to the merits of Booker and Apprendi, though he's never done it in any of his briefs and didn't do it below. His whole argument till now has been that extraordinary and compelling reasons cannot include a change in sentencing law, and even the factors should be looked at in a certain way that is negative here. And now he is arguing on the merits that Mr. Wilson would have no argument under Booker and Apprendi. That's a complicated issue that was never developed below, and he should be deemed to have waived. The government should be deemed to have waived it by not raising it here. And the last thing I wanted to say is to get back to Judge Rogers' question about the text of the lower court's decision noting that she didn't consider this argument. And I turned to the bottom of page 9, where this is the sum total of what the court says about this argument. Defendant spends a significant amount of time arguing that the sentence that he received would be shorter if he was sentenced now, and that this should be considered as an extraordinary and compelling circumstance. This court notes that the purpose of compassionate release is not a revisiting of a defendant's term of incarceration, although a court may look to the length of time served versus the length of time imposed. And then she cites 2 cases where if you basically serve 95% of your time, maybe that would weigh in your favor under the factors. That is not a consideration at all of his change in sentencing law argument. She rejected that could be considered in the extraordinary and compelling side, and therefore only considered this different argument of did he serve almost all of his life sentence? But we'll never know because we don't know how long he will live. So thank you. And we'd ask that you vacate the decision of the district court and remand it back for consideration of all the factors that he did raise, plus this raised below, and he also raised this one, but also consideration of the change in sentencing argument that he has raised.
And thank you, Mr. Shelley. We understand that you've been court appointed and we appreciate your service.
Thank you so much.
Case number 22-5089 et al. Shawnee Tribe and Miccosukee Tribe of Indians of Florida, 20 CD 2792. Prairie Band with Zawatami Nation, 21 CD 12, appellants, versus Janet L. Yellen in her official capacity as Secretary of the United States Department of the Treasury et al. Mr. Blank for the appellant, general issues and issues specific to the Prairie Band with Zawatami Nation. Mr. Abney for the appellant, issues specific to the Miccosukee Tribe of Indians. Mr. Jett for the appellees.
Thank you. Welcome, counsel.
Thank you, Your Honor, and may it please the court. James Blank on behalf of Prairie Band Potawatomi Nation. There was a preliminary, before this argument, Your Honor, this court directed some briefing on the issue of jurisdiction. If the court doesn't have any specific questions on that issue, or if the court wants to hear argument on that issue, I'm happy to offer argument on that issue. Otherwise, I would proceed to the merits. Your Honor, this is the second time that this court has had the opportunity to address Treasury's distribution of CARES Act funds. Under the statutory mandate, the Treasury was obligated to distribute funds distribute funds based on increased expenditures. And the last time before this court, it considered the argument of Shawnee Tribe, which was a tribe that was zeroed out under the IHBG population metric that Treasury had chosen for per capita awards of 60% of the Title V funds. Prairie Band Potawatomi participated as an amicus in that argument, as did my co-appellants, Miccosukee Tribe. When considering Shawnee's argument in that case, a case that Shawnee had lost at the district court level on the issue of reviewability, this court reached at least the preliminary injunction merits and concluded that the IHBG population metric was not a suitable proxy for population. The court therefore remanded. While the case was on remand, the Treasury developed an alternative methodology, what we call in our papers the revised methodology. In the revised methodology, the Treasury took the top 15% of tribes that were most prejudiced by the choice of the IHBG population metric and cut off the remaining 85% of tribes. Within that 15% cutoff, the Treasury calculated what we call the shortfall calculation. The shortfall calculation was a pretty clear calculation of the difference that the tribal government of the amount that the tribal government would have received in a world where tribal enrollment had been considered versus the world that had actually occurred where the IHBG population metric had been considered. This gave us gave Treasury at least, a clear calculation of the difference and the effect of their poor choice of the IHBG population metric. Treasury then took the fatal mistake of implementing what we call the phase out. In the phase out, within that top 15%, Treasury elected to award 88/88 of the shortfall calculation to the tribal governments at the very top of the ratio rank. At the bottom of the ratio rank, Treasury only awarded 188. It created a linearly descending allocation so that the tribes at the very highest received the greatest percentage of funds in that shortfall calculation.
So as I understand it, you make two arguments. One is that the statute prohibited the secretary from doing this. And the secretary responds, well, look at the terms of the statute in terms of vesting discretion in the secretary. Then secondly, as I understand it, you argue that the allocations should have been equal, even if the secretary wanted to phase out in terms of looking at the top 15, whom it considered were the worst off. Everybody within that lesser group should have received the same amount. Have I stated your arguments accurately?
Yes, I think that's a fair summary of our arguments.
So to rule for you, we would have to find that although the statute gave the secretary this broad discretion, in fact, that discretion was limited. And notwithstanding the secretary's consideration of the fact that most of this money had already been distributed, there was some poor data in terms of exact numbers, and the secretary's opinion explains that. She really could only divide whatever amount she found was still available by 15. Why is that a reasonable way to view the secretary's legal authority under the circumstances when she was ruling?
In Shawnee 1, Treasury tried to avoid any review of its allocation. Treasury lost that argument, and this court remanded and granted a preliminary injunction.
Right, so we're beyond that. I'm trying to focus on where we are now in light of our previous decision.
Our argument is that Treasury needed to maintain its allegiance to the statutory mandate. The secretary had a statutory mandate to track increased expenditure, to anticipate increased expenditures, both in 2020 and 2021. There was
Suppose she found that the data, while based on her revised methodology, was much better and consistent with the statute. Nevertheless, she could make no distinctions, maybe for that reason, between the top 15.
So as a preliminary matter, there is no explanation for why, there's no explanation with any connection to increased expenditures that Treasury used in its contemporaneous decision-making on the issue of why it was going to implement the phase-out. That doesn't appear in the administrative record, and it's illogical on its face. If we look at how it affected the actual litigants, we end up with a per capita distribution to Prairie Band Potawatomi of approximately $900, a per capita distribution to Shawnee tribe in excess of $1,700. And on net, we look at an enrolled population for Prairie Band Potawatomi of 4,515 by the government's own numbers, and a enrolled population of 3,000 for the Shawnee tribe. Despite having a total population that's 50% greater than Shawnee tribe, the Prairie Band received 30% less funds, even after accounting for the initial distribution in the IHBG methodology. Your Honor asked about the fact that the Treasury has or that the secretary has tried to excuse her decision-making on the basis of the fact that that money had already been distributed. The case law does not justify agencies deviating from statutory terms just because of finite resources. Really here, Treasury, from the very beginning, there was no chance or no expectation, I don't think, in the statute that that $8 billion was actually going to resolve every increased expenditure that tribal governments were going to face. It was finite resources in 2020. It remained finite resources in 2021.
But
specifically,
the secretary position, and I just want to be sure I understand your argument, is that even if where we are now in terms of the distribution of this money and what's happened, and the secretary's essential acknowledgement about the error of her first methodology, she has changed that methodology, accepted basically your arguments in that regard. But she's looked at, in her or the secretary's view, those who are worse off. And that's the 15. And she makes distinctions between them. And your view is, given the statutory provision about increased expenditures, the secretary would have to determine that any distinction between those 15 must pertain to increased expenditures?
that's correct, Your Honor.
In other words, what I'm trying to understand is, look, the secretary says most of this money has already been distributed, but there are these 15 that are left as the worst off among everybody who is claiming this limited amount of money that's left. And so at this phase, the analysis shifts a little bit. It's no longer at method or at month one, where the secretary has the full amount. That's been distributed. So there's this small amount that's left. And what's to be done with it? In other words, if it were to be distributed, as I think you're arguing, if it went to everybody who was claiming, then it would just be a minuscule amount. On the other hand, if she looks at those who are the worst off, notwithstanding the distribution, she's going to focus on that group. And among that group, she's going to draw distinctions. And your argument is that, given the statutory term of increased expenditures, that is all that the secretary could look at, even if she could find these 15 are the worst off, and that even with the new methodology, there was bound to be some uncertainty about numbers. And Secretary's reasoning explains that. And so she made a judgment. I keep saying she, but I mean the secretary, just made a judgment about, what do I do with this very limited amount of money? And you're just saying that is clearly not authorized by the statute, and it's an abuse of discretion.
That's correct, Your Honor. Within the 15%, which amounted to 88 tribes, the secretary should have endeavored to equalize the per capita payments. In the methodology underlying the 2021 revised methodology, there's no statement of why we're going to move away from justification for moving away from a per capita approach. Really, but if you read the statement, it's simply saying we're going to make enrollment-based allocations rather than IHBG-based allocations, and then they implement phase-out. The phase-out, without justification relating to increased expenditures, creates these perverse gross disparities in distribution. When the Treasury had the shortfall calculation, that gave them that would have given the Treasury a very straightforward lodestar to resolve this with more than $80 million in funds. I don't think that there's any, in other words, there has to be some justification. It's not that Prairie Band is on its own. It was intentional that Treasury would distribute funds to create these gross disparities in per capita distributions between the low end of the 15% and the high end of the 15%. And there's no rational basis, there's no rational even post hoc justification that's ever come up for that. It's just excuses about the finite resources, excuses about discretion, and that is not meeting the burden of rational decision making by agencies.
Let me go back into the record a little bit here, because it appears that within the briefs, the trial record, that the numbers keep changing. And so do you all have an accurate basis for what actually got paid out? What were those distributions? What statistics were used in terms of populations and things of that nature?
At many points in the course of this, those numbers were very opaque, even to the litigants. If you look at the record, there's no hard and fast statements regarding what numbers were used when. For example, both in 2020 and 2021, the Treasury had solicited enrollment figures, which the litigants led litigants to believe that those solicited enrollment figures were the ones that would be used. Ultimately, we found out that they used enrollment figures that had been maintained by the federal government, separate from the solicitation. The Prairie Band received approximately $4 million in sum from the 2020 distribution and the 2021 distribution. And in addition, that 2021 distribution, because of an intervening error that was subsequently corrected, there was a disparity between the time that the case was commenced until in time that the second amended complaint was filed until we sit here today, in which another payment was made. Likewise, Miccosukee received a payment in 2022, but there's no dispute, and the Treasury's briefing on this is quite clear that Prairie Band would be could conceivably be entitled to relief from an additional payment, and that Prairie Band has not been treated the same as Miccosukee tribe, as Shawnee tribe.
And you don't, do you dispute the different methodology that's used the second time, or is it just the rationalization for that methodology?
We dispute we note that the rationalization is lacking. We note that it's lacking, but we dispute the methodology. We don't think that there could be any rational basis to treat these tribes at the top and the bottom of the 15% cutoff with such gross disparities that a tribe would receive half of the per capita distribution. Prairie Band received $900 per enrolled member, whereas Shawnee has received approaching $1,800 per enrolled member.
What's the remedy at this point? Because there's obviously a lot less left. And so what's the remedy at this point?
Prairie Band proactively obtained an injunction on $7.6 million at the same time that Miccosukee obtained an injunction of approximately somewhat less than $2 million, which left $9 million at issue. Those funds have been drawn against in the 2021 distributions. Those funds remain, and those funds, our understanding is that those funds are sufficient to bring Prairie Band Potawatomi in parity with the best treated tribes within the 15%. The court should direct, and I understand that there's not enough data in the record to give the court a specific dollar value. But what the court should do is remand and direct Treasury to make an award that brings Prairie Band, Potawatomi, and Miccosukee tribe, to the extent they have not already been treated so, into parity with the best treated tribes within the 15%.
But how do they do that in terms of any calculation other than you asking us to make them award exactly that 7.6 million? Should they be using any type of methodology, or are you asking us to just direct them to that payment?
No, Your Honor. I think that the methodology would be encapsulated in the we think that the way that the best treated tribes were treated was a fair way of treating the best treated tribes. Every other tribe after that 88 out of 88 was treated unfairly. We would want to be receiving funds on the 88 out of 88 fraction.
Okay.
So there's no additional calculations that need to be made. In fact, Treasury has demonstrated that it has both the funds and all the data it needs to make subsequent distributions to tribes like Miccosukee tribes and other tribes that were near the top to equal them out with the 88 out of 88s. And that those payments went out, our understanding is only weeks ago. So we don't think that there's a great deal of additional number crunching that needs to occur for Prairie Band to have a remedy here.
But I'm trying to wrestle with the fact that they have discretion. They're supposed to use that discretion based on the increased expenditures and rationalize that. So we can't really direct them to say this amount of money automatically paid to Prairie Band and or the other tribes. So I'm trying to get a balance of that. When you say remand, they're still supposed to have some judgment in how they come up with their calculations. So how do we attribute language correctly to make sure that they do that and that we're not back here?
The language should say that Prairie Band Potawatomi is entitled to be treated on the same terms as the best treated tribal government within the top 15%.
And Judge, when you were responding to Judge Rogers earlier, you were using the term worse off. What data, or how do we consider who's worse off in this regard?
We think that these justifications that we see that weren't in the contemporaneous decision making, but did appear in arguments before the district court and were adopted by the district court, are flat wrong. There's no way that the 0 tribes or the 88 out of 88 tribes was wronged in a way that is different in kind than the way that Prairie Band Potawatomi was wronged by the choice of the IHPG population metric. It's a qualitative versus quantitative distinction. Everything could be captured in that shortfall calculation, which was the entirety of was the way to quantify the harm in a way that was connected to increased expenditures, and anything that would consider any other sort of harm, optics harm, some sort of harm attributed to a 0, including the number of 0. Those to the extent that's a harm at all, that's not a harm. This is not a remedial statute. There was no intervening change in the law that allowed this to work as some sort of remedial statute as an apology to the 0 tribes. They should have approached it on a one-to-one quantitative basis with the error to the tribes at the top of the 15% and at the bottom of the 15%.
And is this request that you would have, would that be a reversal or vacate the judgment? Do you have thoughts there?
It would be a reversal of the district court's decision.
Counsel, let me follow up on Judge Child's question. This court, in order to rule in your favor on the question of law, would rule, as I understand it, that because of the statutory requirement of increased expenditures, that is the only legal factor that the secretary could properly consider. Therefore, wouldn't it follow as to, in terms of the secretary's responsibility, to follow the law as clarified by this court as you request, wouldn't the secretary be required to take whatever amount is left, look at the increased expenditures, if any, by all 85 of the tribes in the top 15%? See what each can come forth with, and then allocate. And it may well be that your client or the appellants, petitioners, would not end up at the top, but along the lines you're arguing, the secretary would have followed the statutory directive of increased expenditures. So, I mean, for all the reasons Judge Child's question suggested, but I just want to be clear that even accepting your legal argument, our order of reversal and remanding, as you would request, would not at this point be able to direct that appellants end up at the top. Do you get the point? That if we hold that there was a violation of law in distinguishing because of the statutory provision and the secretary's failure to provide an adequate explanation, the secretary would have to look at all 85. And just suppose hypothetically the secretary did so and had firm figures to show that, just hypothetically here, some of the other 85 had greater expenditures than the appellants here. Wouldn't the secretary be obligated to adjust the awards accordingly?
I don't think it's necessarily the case that
I don't understand. We're telling the secretary, in your view, that the secretary was legally in error not to consider the statutory factor and send it back. And you seek an order that says giving appellants preferential treatment. But how could we do that without getting the information that you say the statute requires from the secretary and then seeing what the secretary comes up with?
I think that Shawnee 1 is instructive on this point. The remedy in Shawnee 1 was not a simple remand. It was remand with specific instruction to the district court to implement an injunction in the amount that Shawnee had asked for. I think this recognizes that even if all the tribes can't, if every tribe can't be resolved and every error can't be resolved, it's rational, or it's acceptable for the court to fashion a remedy that would allow at least the litigants to have a remedy and to be treated fairly and to not be treated arbitrarily and capriciously. That's implicit in the injunction that the court ordered in Shawnee 1 to be implemented.
So if the secretary on remand were able to come up with a rationale and explain it, wouldn't that suffice? In other words, I'm not sure the remedy, and maybe I'm wrong about this, and maybe Judge Childs and Judge Silberman will disagree, that the remedy can be quite as simple as you request, reverse and remand, and the appellants get as high as the top tier. Isn't it a bit more complicated if we say there was an error of law?
The Treasury, as recently as 6 weeks ago, made payments to several tribes that were no different than the amounts or than the concept that Prairie Band is seeking to obtain.
I understand that, counsel. Maybe we just drop this because I realize our argument has gone over, but that's one of the concerns I have on the remedy you seek.
Sorry, Your Honor, just to put a pin on that, any remedy, any amount that fixes the shortfall that fixes the shortfall embodied in the 2021 distribution would be a win.
No, I understand that point. Thank you.
Thank you, Your Honors, and may it please the court, George Abney on behalf of the Miccosukee Tribe of Indians of Florida. I think it's relevant to let the court know that for the Miccosukee Tribe and for many other Native American tribes, the past is not really the past. The past is always present for the Miccosukee Tribe, as it is for many other tribes. In the past, and the Miccosukee Tribe's unique history informs how the tribe operates and carries out its business on a day-to-day basis, even today.
So, counsel, could I just be clear that in the supplemental brief, the secretary argues that the tribe has received all of the funds to which it was claiming. Are you disputing that, or have you conceded that?
We have received the supplemental payment of approximately $117,000 that Treasury represented they would be sending to us.
And however, is that what the tribe sought?
No, Your Honor. What we sought in our claim below, and this is in our second amended complaint, is to be treated consistently with how tribes were treated in the 2020 distribution, and that amount is reflected in the amount of the injunction that the Miccosukee Tribe sought that this court ordered and that the district court put in place. And that amount is approximately $2 million. Thus far, the Miccosukee Tribe has received just short of $1 million.
All right. So what else did you make clear that you were seeking from the secretary?
Well, this case is about receiving funds. And so we believe that we have made our case clear at the court below that what we were seeking is to be treated on par with tribes that received a distribution in 2020 of approximately $3,000 per member. Thus far, Miccosukee has received a distribution of approximately between $1,500 and $1,700 per member. And that is a significant disparity, Your Honor. Okay,
I get that, but I'm trying to understand this additional amount. If your injunction was for $2 million, and that was to make the tribe whole, and let's just hypothetically assume, as you admit, that you received $1,700, and let's also assume, if for purposes of argument, that the tribe gets the other $300, then has the tribe received all the relief? I mean, this is just a jurisdictional question, counsel.
No, the tribe has not received all of the relief that it has claimed in the court below.
And you would point me to?
I would point you to our second amended complaint, where we requested to be treated on par with the tribes that received a 2020 distribution of approximately $3,000 per member. And I would also point the court to the injunction that was entered in the court below, and the approximately $3,000 per member calculation resulted in approximately $2 million being placed under injunction at the.
So you're suggesting that issue is not moot then?
No, we do not believe the question is moot. And further to that point, Your Honor, I certainly give the government credit for attempting to remedy an error in paying Miccosukee an additional amount of funds, but there are certainly lingering questions about that error, and we don't have enough facts in front of us. We don't believe the court has enough facts in front of us to determine whether or not Miccosukee is now being treated on par with the other 0 tribes that received a distribution, a second distribution in 2021. The record is just, it's really just a letter from Mr. Jed, and it's the fact that we did receive an additional payment. We have no idea what the other 0 tribes may have received. We don't know if we're being treated on par with the other 0 tribes. So we don't believe our question is, our case is moot. And anytime new facts are introduced into evidence, of course, those new facts need to be held up to scrutiny and examined, and we have not had the opportunity to do any of that.
So I would
go ahead. Excuse me, Judge Jones.
go ahead, Judge Rogers. Thank you.
No. You finish your thought.
No, I was just going to ask you the same question about the remedy, because if we send it back and then there's a recalculation on method, given discretion to the Treasury with respect to the method of allocation, are you risking, again, as Judge Rogers was indicating, perhaps a pro rata share, perhaps a description of being placed back into the pot, things of that nature? So what's your view on the remedy?
Well, Your Honor, and we provided some supplemental briefing on this point, and maybe the supplemental briefing that we provided didn't quite answer all of the court's questions. But I think, I'm not sure how much CARES Act money the Treasury has left. Apparently they have some amount of money left, but we don't know the precise amount of that money. But there remains approximately $7 million under injunction, and that money, approximately $5 million, is reserved for Prairie Band. Approximately $2 million is reserved for Miccosukee. I'm sorry, approximately $1 million remains for Miccosukee. I don't know the exact number that's under injunction, but it's my understanding that those funds are reserved for payments to Miccosukee and to Prairie Band, and I don't believe there's any bar using those funds to pay Miccosukee and Prairie Band. And it's a matter of appropriations law, and perhaps some supplemental briefing would be appropriate on this issue, but if another tribe were to file a case today or tomorrow, I don't think they would be entitled to any of those funds that are under injunction right now. So I don't think we really run the risk that.
Well, and that's what I was getting at too. You say under injunction for just those 2 tribes, not to go back to a general pot?
That's my understanding, Your Honor.
And your understanding comes from where?
My understanding is Judge Maida's order specifically reserved that money for Miccosukee and Prairie Band. And the 2021 distribution and then the 2022 distribution that Miccosukee received, $117,000 recently received, all of that was drawn down from the money under injunction. And that other monies that were paid to other tribes other than Miccosukee and Prairie Band, those came from some other source that sort of remains unknown. We don't know. Apparently, it's some CARES Act money that was left over from the distributions to the Alaskan Native corporations in the Chehalis case. But I don't really profess to have a lot of insight into other monies that Treasury has.
Well, I'm afraid, counsel, the burden's on you in part here to persuade us that in obtaining the injunction, and we have to look at the record here, obviously, in more detail, the tribe didn't get what it was asking for. And so the government's obligation went up to 2 million. If you get the 2 million, the government has satisfied your claim. In other words, it's a settlement. We're going to put this injunctive relief as to the 2 million. When we pay you that, all claims are satisfied. And you're saying, well, you're not that familiar. Well, I mean, I understand parties seek relief beyond the relief that the district court may award, But I'm trying to understand what was the nature of this injunctive relief. And that's why I started off. Let's just assume you get the total 2 million. Why isn't your claim resolved, as it were? And I mean, you're likely more familiar than I, and Judge Childs certainly is. You know, parties file complaints seeking relief on multiple grounds, but ultimately they may resolve matters with the other side and agree to some other figure or some other relief. And the case is over. That's what we're trying to nail down, because certainly the supplemental brief filed by the government suggests that. And you haven't disputed it. And that's why it was my first question. But at any rate, I think we understand your position, subject to any questions that Judge Childs may wish to.
May I just address briefly the points that Your Honor made? Your Honor, the relief we are seeking is the 2 million that we sought initially when we filed our complaint and then filed our second amended complaint. We're not seeking relief beyond that 2 million.
That's right. So if you get your 2 million, you're satisfied and the matter is moot.
That's correct. But thus far, we've received only approximately 1 million. So I think
said there was another payment, so you've got 17. Anyway, I just want to be clear about that. And I think I'm clear now. And that answer may also affect the other tribe appellant. Thank you, counsel.
Thank you, Your Honor.
Thank you.
Morning, Your Honors. Adam Jett on behalf of the federal government. May it please the court. I'd like to begin, if I may, with the colloquy that Judge Rogers had with actually both of my friends about the statutory standard. Because the question, just if you look at the statutory text, is not some sort of philosophical distributive conception. The question is whether the Secretary has made a determination, one within just a zone of reasonableness, that the payments are based on increased expenditure. Now, there is inherent uncertainty. You're trying to estimate and trying to predict what increased expenditures are going to be. And so I think it's common ground among all the parties here that the issue is just selecting a proxy. The question is, which population measure is not necessarily the best proxy, but is at least within a zone of reasonableness, is to sort of use the language that this court used in Shawnee, is not so unreasonable that it can no longer be considered a proxy for increased expenditures. And I think then that the plaintiffs can kind of tip their hands, actually when both of them were at the podium, when they start referencing per capita payment. This is question begging. When the plaintiffs stand up here and say, one tribe received X amount per person and a different tribe received Y amount per person, they're presupposing that the relevant count of people are the number of enrolled members. In other words, their whole argument is assuming the answer that they want this court to reach. But the question, everyone agrees that for the purposes of this proxy distribution, it will be per capita. The question is, what's the capita? Are you measuring the number of people based on the enrollment in the tribe, the number of citizens, no matter where they live? Or are you measuring the number of people based on the number of individuals who live in their formula area population, or some blend of those two figures?
But the statute refers to increased expenditures. So based on what you're saying here, how does that formulate with increased?
Sure, absolutely, Judge Childs. So just stepping back again, I think everyone, it is common ground in this case, everyone agrees that using some population measure is kind of acceptable as a proxy for increased expenditures. And maybe if I could just sort of briefly walk you through the administrative record. As the agency explained from the very beginning, you can find this at JA 751 to 753 and then 755 to 756. The idea is that again, there were sort of three different tranches of money that were given out here. For the population-based tranche, the idea is that the more individuals that a tribal government is providing services for, the more, again, this is just an estimate, back of the envelope prediction of what will happen, but the more likely it is then that they will have more expenditures, these sort of person-based expenditures, as a result of the COVID-19 pandemic. I think the agency specifically talked about expenditures such as providing medical services. Now, that's the reason that the agency initially decided to use as a proxy the formula area population. This is a number that has been used by HUD and by other agencies to sort of figure out the population of people that a tribe is providing certain services for. And it's a number that essentially sort of captures the population of folks who live around the seat of the tribe where the tribe is exercising control and the tribe is exercising services. Now, obviously, the plaintiffs believe that there's a different number that should be used, that the number that should be used is enrollment, the number of citizens, no matter where they may live. In this court, in the Shawnee decision, and I think it's very important that this not get lost, said that it didn't rule definitively, but sort of as a likelihood of success on the merits, it said that for zero population tribes, where the formula area population is zero, that for those folks, it seems like formula area population is not a reasonable proxy. And so the government responded to that, such that for the zero population tribes, the government is solely using enrollment. At this point, the amount of money that a zero population tribes receives is the amount they would have received if all federally recognized tribes have been evaluated solely based on enrollment and not by using formula area population. And then for the sort of additional number of tribes that are kind of close to them, that have low populations, may very well be meaningful, but conceivably are low and somewhat disparate from their enrollment, there's a sort of additional plus up that's been provided. And I actually think this may then kind of pivot nicely to the colloquy that Judge Rogers was just having with my friend at the end of the argument, because when my friend indicates that they were seeking $2 million, obviously none of this has been briefed, this is coming up for the first time at the podium, but if your honors do go back to look at the sort of relevant district court filings, the $2 million figure that the Miccosukee were seeking was, and I apologize, I keep looking at the screen, but I realized the camera is actually in front of me. The $2 million figure was essentially a calculation that was reached based on using enrollment for the Miccosukee, or it may have been from the Miccosukee and the two other plaintiff tribes, but then using formula area population for everyone else. But at this point, what the Miccosukee has received is a sort of per capita count that solely, they used enrollment for them, premised on the idea that enrollment had been used for everybody else. And I think then that sort of paradox actually then plays in nicely, Judge Childs, with the colloquy that you were having with my friend about remedy, because essentially what my friends are asking for is they're saying, so Prairie Band, for example, was ranked number 63 on that ranking of ratio. They're saying, treat number 63 in the same way that you treat number 1, sort of plus them up entirely such that they receive what they would have received if everyone had received money based on enrollment. But skip over everyone in between, and by the way, ignore everyone underneath us. But if what my friend was saying was correct, if there was some reason that enrollment is better, if there's some reason that the ratio between enrollment and formula area population is relevant, then either it's better for everyone else or it's relevant for everyone else. And that's then where the sort of redistribution formula comes into play, because the whole idea in 2021 is the secretary started with what this court said in Shawnee, where this court said in Shawnee, if you have tribes that have enrollment, a formula area population of 0 and have a high enrollment, there's at least reason to believe that basically formula area population just isn't capturing what it's supposed to capture. Now, in other words, to sort of go back to the relevant statutory terms, that the number being used is no longer within a zone of reasonableness as a proxy for increased expenditures. And so that's why then, for the 0 population tribes, which now include Miccosukee after the government corrected the relevant error, that they're receiving funds totally based on enrollment. And then for others, it's just a weighting. It's essentially a sort of mashup of the two numbers. And because the whole idea is that the disparity between the two numbers calls into question the accuracy of using formula area population, the greater the disparity, the greater the plus up. So for the 0 population tribes, they're plussed up all the way. And as you go down and the disparity gets smaller and smaller, the redistribution gets smaller and smaller. And one thing that I want to make sure doesn't get lost in this discussion is it's not just a redistribution out of the general treasury. Remember, these are funds that are being taken away from other recipients, here from the ANCs. And the plaintiffs haven't argued that there was any kind of error in giving funds to the ANCs. They haven't argued that there's some reason the ANC should have received less funds. The ANCs just basically had the misfortune of having their funds tied up while there was a legal question that got litigated all the way up to the Supreme Court. So at this point, basically, every dollar that is sort of given to the plaintiffs is then taken away from someone else who also has a claim to that money.
So you don't believe that plaintiffs representing what's left just goes to them?
I think if nothing else, obviously the government hopes that the district court's decision is affirmed, and sort of happy to explain why the government believes the district court's decision was correct. If the court were to determine that the district court erred, obviously, what happens next, of course, would depend on the basis for this court's decision. If, for example, the court said, well, theoretically, what the government did might be substantively reasonable, but there just wasn't enough explanation. And again, I'm happy to tell the court why I think there was enough explanation. But if the court concluded that there wasn't, then it would go back to the agency, and then the agency would have the ability to sort of make a further explanation. If there was some other substantive error, if there's some reason, and it's really hard to imagine what this is, but if there's some reason that, for example, if you look deep within the heart of the statute, the term increased expenditures actually means use enrollment for the top 88 and then switch to formula area population as soon as you jump from 88 to 89. Hard to imagine how that could be the case. But if that were the case, then I think then you get a remand and it goes back to the agency. And again, this is just black letter administrative law. The agency then takes into account whatever the court said and can then make a sort of further distribution. And so I think when the colloquy was happening with Mr. Abney about what the appropriate remedy is, and he suggested that the kind of reason that this preliminary injunction was entered in the first place is to benefit his client and to benefit Prairie Band. I don't think that the fact that they got a kind of particular interim relief can then be used as a kind of foot in the door to kind of work backwards and force a particular remedy on the agency. So as for the kinds of appropriations questions that were at least referenced up here, obviously the parties haven't briefed those at all, and I don't want to sort of stand on my feet and opine on what would be a sort of somewhat unusual application of appropriations law. But normally the black letter law is sort of once there's money that's kind of held up in litigation, even when an appropriation expires, that money can continue to be spent, to kind of satisfy what ends up being the sort of final judgment in the litigation. Now, ordinarily, final judgment in an APA case is you set aside an action that's arbitrary and capricious, and you send it back to the agency to redo that action in a way that's not arbitrary. I don't want to get ahead of the agency. I think the agency could potentially choose, depending on what this court said, to distribute the funds in different ways, and the sorts of appropriations issues that my friend referenced, I think would be fair game for the agency to consider on remand, but I think it would be highly premature for the court to consider.
Well, I want to go back to you suggesting that you have explanations, because it did not appear that those were really in the record in terms of the data that you're relying on. And as I indicated earlier, there just seems to be a lot of different numbers and moving targets throughout the record.
Sure. So I guess if I could sort of briefly just address the kind of conceptual issue with numbers and moving targets, and then if I could kind of specifically kind of walk the court through the explanation. So as for kind of numbers and moving targets, as I began, this is all about proxies and estimates, because remember, as this money was going out the door, no one knew exactly what the increased expenditures were going to be. This was all an issue of what was going to happen in the future. In 2020, initially we thought it was funds that would be expended throughout 2020. Congress actually then amended the statute so that it would include funds that were expended through the end of 2021. So everything was just a sort of question of future predictions. The data sets that were being used, I think the agency was extremely clear on. The whole conversation was about enrollment versus formula area population. The agency decision spells out in some detail exactly what formula area population is, that they're taking it from HUD. I think they actually cite the relevant regulations, the relevant HUD regulations, which set up how formula area population is calculated. So as for that, I think the sort of data is pretty clear. And just in case this is what Your Honor was getting at, it is black letter law. I think the Supreme Court's recent decision in Prometheus, among other things, establishes this, that an agency can't be required to sort of go out and just kind of create a whole new data set. An agency is allowed to basically use the data it has access to. And so the data that for purposes here were being used as potential proxies for increased expenditures, in addition to the expenses and the employment data that nobody is disputing here, for just one of these two populations. So then, as for whether the agency provided a sufficient explanation for the phase out, because again, I think it is common ground here. Everyone agrees that zero population tribes at this point should be, or at least are, and this is undisputed, receiving funds as if all federally recognized tribes had been evaluated based on their enrollment. So the only question then is just whether there should be a sort of taper down, or as I think Prairie Band is arguing for, basically whether the tribe in 63rd place should be treated the same as the tribe in first place. And then once you hit 88, there should be a fall off. And so I just want to make sure that the court kind of sees the explanation that the agency provided. We spell this out to some extent if the court sort of wants to look at a further discussion of it on pages 47 to 49 of our brief. But basically, the concern, the whole thing that motivated this, stemming from this court Shawnee decision, is the disparity between the two measurements. And you can find the agency's discussion at JA 1395 and JA 1400. And so because it's the disparity that kind of raised this question of whether the initial measurement, formula area population, was an unreasonable proxy, then further adjustment that gets made, and now I'm quoting the agency's decision on page 1400, the adjustment is, quote, based on the disparities. So I think there's sort of a little bit of a game of shadow boxing going on here, where the plaintiffs say it was sort of an unexplained fait accompli, that the agency just never explained why it is that there was a taper, why it is that there was a phase out. The agency didn't explain it twice. In other words, the agency didn't first say, what's driving us are the disparities, we care about the magnitude of the disparities, and then again say, we're going to have a phase out, and the reason we're having a phase out is what's driving us is the disparities, and the phase out would be based on the disparities. But there's no legal requirement that an agency say something twice. When you're looking at an agency explanation, again, this is just black letter administrative law, as the court well knows. You read the explanation as a whole, and the question, just to use the sort of governing Supreme Court standard, is whether the path may reasonably be discerned. And so when the agency says the concern is the disparity, and we're making an adjustment based on the disparities, and then they sort of say they're going to have a taper, a phase out, and they explain the formula. The taper and the phase out is following logically from the issue of disparities. In other words, if you're having an adjustment based on disparities, the less the disparity, the less the adjustment. Unless the court has any other questions.
What do you make of the district court's in Shawnee 1 statement about there will be a likelihood of success on the merits?
Your Honor, I apologize. I couldn't quite hear
What do you make of the district court's statement in Shawnee 1 about there being a likelihood of success on the merits?
Well, Your Honor, I think Your Honor is referring to this court's decision and what's being referred to as Shawnee 1.
This court's decision.
So I think this court's decision in Shawnee 1 underscores everything that the agency did in response to this court. So this court, if in Shawnee 1, if you look at the decision, the sole plaintiff there was what is being kind of colloquially called a zero population tribe. It was a tribe that had zero formula area population, but did have a significant number of employees. One of the amici, Miccosukee, who is now a plaintiff here, was also a zero population tribe. And with respect to the plaintiff there, and then the court suggested that this might be true for Miccosukee as well, it said, I mean, if you just read it, it repeatedly refers to there being zero population tribes. And it says, for these folks, zero population tribes, it looks like using formula area population is an unreasonable metric. And so Treasury responded to that. And in fact, what Treasury has now done is for all of what are being called the zero population tribes, formula area population has entirely dropped out. All that is being considered is enrollment. And again, just to be clear, enrollment isn't being considered only for them and no one else. They've received what they would have received if everybody had been evaluated based on enrollment, which is what they have been looking for the entire time. Now, I should point out, my friend from Prairie Band was standing up here, and he indicated that Prairie Band filed an amicus brief in Shawnee 1. Notice that in Shawnee 1, this court referred to the facts of the amicus Miccosukee. It didn't refer there to the facts of Prairie Band. And, you know, as we spell out in our brief, this is the sort of nature of an agency having discretion. I think in response to Shawnee 1, one thing that Treasury could have done is said, look, the DC Circuit has indicated that when there's just zero formula area population, basically just no one knows what to make of that number. Maybe that number can't be trusted. Maybe it's not a reasonable proxy, and could have stopped there. Could have only provided additional funds to those who had zero formula area population. But instead, the agency went a little bit further. And the agency said, you know, some of this court's logic, sort of some of what seems to be driving the concern about the zero tribes, could potentially stretch a little bit further. And that's why you end up with this kind of boundary zone past the zero population tribes. And that's why Prairie Band is kind of having this conversation at all. Because when you have a tribe like Prairie Band, which does have a meaningful formula area population, the fact that its enrollment is greater than its formula area population could be the very reason that the agency selected formula area population in the first place, which is that's the number of folks who kind of live near the tribe. The tribe is generally entrusted with providing services to. And by the way, just to make sure that this doesn't get lost, although the plaintiffs here are plaintiffs where their enrollment is higher than their formula area population, there are plenty of tribes, and we cite some examples in the record of tribes talking about that, where those tribes' formula area population is a lot bigger than their enrollment, because there are plenty of tribes who are providing not just for their own members, but are providing for lots of Native American members of other tribes, some of whom may very well be enrolled members in the plaintiff's tribes and would potentially be double counted. So, you know, again, just stepping back, at the end of the day, this is the nature of administrative decision making. You can't predict the future. You can't do anything perfectly. The question is just whether Treasury has acted within a zone of reasonableness in predicting whether there's increased expenditures. And again, just to say this one more time, with a limited pool of funds, in not taking essentially an infinite amount of money away from the Alaska Native corporations, who nobody has disputed were properly assigned the initial amount of money that is now being taken away from them.
Thank you. Judge Rogers, any questions?
No, thank you.
Thank you.
Thank you.
Okay. All right.
Just quickly, one note about the record, and this is an important note. Mr. Jed makes reference to Joint Appendix 1400, where Treasury for the first time mentions based on disparities. 1400 was not contemporaneous with the revised methodology. 1400 comes out months later when Treasury is actually figuring out this single race versus multi-race issue that had resulted in prairie band receiving successive payments. They've already seen the second complaint at the time that Joint Appendix 1400 is developed by Treasury, and they're already anticipating the arguments that are raised in the complaint and trying to rebut them. It's not contemporaneous decision making. Treasury in its own, and Treasury even in that concedes at that point in the record concedes that it's not based, that the 2021 methodology is not based on increased expenditures, but it's based on these disparities. And Treasury repeats this point at pages 30 and 32 of its brief. You didn't hear any connection between to justify the differential treatment for prairie band receiving $900 per person, whereas the tribes at the top received approximately $1,800 per person. Nothing at all that's connected based on increased expenditure. Mr. Jed makes reference to the idea of blending, that there's some sort of weighing of the two factors. That's not the case here. If there had been any blending, it wouldn't be the case that prairie band, with a far greater 747 IHBG population and a 4515 enrolled population, would be receiving $1.3 million less than Shawnee tribe that had a 0 IHBG population metric and 3,000 enrolled members. If there were a blending, there would be some convergence. There's no convergence. It's total inversion of the original approach.
Okay, anything new?
That's nothing further, Your Honor, unless you have any further questions for me.
Judge Charles may have some questions.
I don't. Thank you.
Thank you, Your Honors. I do want to address a couple of points that Mr. Jed made, and I want to emphasize for the court that our Miccosukie's case is not moot. We dispute his representation that all 0 tribes have been treated equally. We don't have any information in front of us. The court doesn't have any information in front of the court to determine whether that's accurate or not.
But counsel, the statement was not that, but that simply in obtaining the injunction by the district court, Miccosukee agreed that upon receiving the $2 million, its claims were satisfied.
Your Honor, and I don't want to cut you off, we have not received the $2 million. We've received $1 million.
Counsel, you said that several times, and my hypothetical was based on the assumption that the secretary is not going to violate the district court's order of injunction. That's all. So you get your $2 million. And if you get your $2 million, your claims are satisfied. And I thought at the end of your argument to us, you admitted that.
Yeah,
and
if
what
we
you're
get our
saying now is just what you said before. And it doesn't in any way undercut that in getting the injunction for $2 million, upon receiving the $2 million, your claims are satisfied. And you may have had other claims, but you agreed to this injunction that the district court entered in your favor. So
and that is all correct, Your Honor. But my point is, and we agree, if Miccosukee receives the $2 million, then we are satisfied. But
good.
We have not
Good. All right.
received $1 million. And the last point I wanted to make is,
See, counsel, in reply, that is nothing new. You're just repeating, and you're not taking back your statement that when you get the $2 million, your claims are satisfied.
that's correct.
All right, fine.
So, Mr. Jett, I do want to address his point about a zone of reasonableness. And of course, we don't dispute that a zone of reasonableness would apply in most APA cases in attempting to evaluate the government's decision-making in an APA case. But consider the facts here. The formula which they are defending did not produce results that are in a zone of reasonableness. It produced these skewed results. So a tribe with an IHBG formula area population of 600 receives $2 million, but a tribe with a population of 600 receives only $1 million. That is not within a zone of reasonableness. That is the definition of disparate treatment, and that clearly is arbitrary and capricious.
Well, with all due respect, the zone of reasonableness does not only look at the dollar amount, but it looks at the context in which the secretary is ruling. So,
and I'm happy to address the context,
all right.
Your Honor.
If you get your 2 million, you're satisfied.
We definitely are satisfied if we get our 2 million.
Thank you.
Thank you, Your Honors.
Thank you. Of course, the court will take this matter under advisement. Thank you.
Case number 21-1195 et al. Fairless Energy LLC petitioner versus Federal Energy Regulatory Commission. Mr. Buchholz for the petitioner, Ms. Benta for the respondent, Mr. Bennett for the intervener.
Good morning, Your Honors. May it please the Court, Jeffrey Buchholz for Petitioner Fairless Energy. Your Honors, I'd like to make 2 points about the 2 related errors that FERC made in the decision below here. We had a state law contract claim governed by Texas law that the parties, our predecessor Dominion and Transco, agreed on the rate that would apply under this contract, and that they agreed that the Zone 6 to Zone 6 rate would apply. FERC made 2. First, FERC erred grabbing that Texas law contract issue from the Texas court and deciding to exercise primary jurisdiction. And second, FERC compounded that error by then refusing to actually adjudicate our Texas law claim under Texas law and instead assuming it away. So first, I think I want to make sure that I'm clear about what our claim is, because FERC has persistently refused or been unable to understand what our claim is. Our claim is that notwithstanding Exhibit C, saying that there's not a quote-unquote negotiated rate, that the parties nonetheless, our predecessor Dominion and Transco, had a meeting of the minds that the Zone 6 to Zone 6 rate would apply. And FERC has just never acknowledged that that's our claim. They've never acknowledged that's our claim. They've never dealt with that claim. And that's
because FERC takes the position that you signed a contract with Transco. You had a chance in that contract specifically to state any negotiated rate, and that contract says there is none. And so that's clear, and there's no basis to consider extrinsic evidence. And why isn't that law applicable here?
But Your Honor, again, I want to be clear what our claim is. We understand that
I get your claim. And I'm just saying your client signed a contract. And whatever your Texas claim was as to the contract it signed with Transco, here's what it said. And there's no ambiguity about what it said.
So, Your Honor, first of all, Texas law recognizes the concept of latent ambiguity, where the analysis is not as simple as you look at the document in isolation. We understand that Exhibit C says none. We're not arguing that there is a
I don't
negotiation.
see Texas law to say that when the contract, the four corners of the contract are clear on its face, it is permissible to consider extrinsic evidence is to the party's contrary intent. What's your best case for that?
There's two Texas Supreme Court cases that Coker and J.W. Hampton that say that the contract is not unambiguous, despite what it might look like on its face. That again, the Texas Supreme Court has repeatedly recognized the concept of a latent ambiguity, where you take the document, you apply it to particular facts, then an ambiguity arises. And in those two cases, the Texas Supreme Court remanded for the trial court to determine the actual intent of the parties.
And what is your latent ambiguity?
Latent ambiguity here, Your Honor, is not whether there's a negotiated rate. We understand that there isn't a negotiated rate. Exhibit C says that there isn't. Our claim is that nonetheless, the parties here, our predecessor Dominion and Transco, had a meeting of the minds about what rate would apply under the tariff, that agreement was Zone 6 to Zone 6 rate. Now, the contract says, this is at JA76, in the article governing rates, it says that the buyer shall pay the seller in accordance with the seller's tariff that's been filed with FERC, as that tariff may be amended from time to time, et cetera. So the contract here, I want to be clear about this, does not say that the parties agreed that the market link incremental rate will apply. If that's what the contract said, then it would be fair to say we'd be trying to change the terms of the contract. But that's not what it says. The contract doesn't specify which rate under the tariff applies. Our position is the parties in their negotiations had a meeting of the minds about which rate under the tariff. There's 30-something rates under the tariff. And our position is the parties had a meeting of the minds that the rate that would apply was the Zone 6 to Zone 6 rate.
And now, so why is that not a negotiated rate when the contract that your client was taking over, as you point out, always had these different rates specified? And now in the contract, the new contract that your client signs with Transco, it says there is none. And it doesn't deny that it's receiving service over this extension where Transco has always charged this additional higher rate in the absence of a negotiated rate. I mean, why would your client say none? That's what's inexplicable. I don't know why that's latent.
So, Your Honor, first I want to make clear that it wasn't our client. Our client, Fairless.
I'm sorry, whoever was representing Fairless at the time, or if it was proceeding pro se. I didn't mean to bring your law firm into this.
No, I'm sorry, Your Honor, that's not what I meant. This is an important point. Fairless was not the original party to this contract. Fairless's predecessor, Dominion, was. So Fairless was not.
I know. It negotiated a new contract with Transco.
Your Honor, I'm trying to answer your question about why parties to the 2018 contract wrote what they wrote. And part of my answer to that is, I don't know, because my client wasn't one of those parties. My client came in later and inherited this contract from Dominion. And so that's why we've said throughout in the Texas court and in all the FERC proceedings that we need discovery and an evidentiary hearing, including to take evidence from Dominion, which has that firsthand evidence that we don't have through no fault of our own, about what occurred during those negotiations. Our position is, we're not claiming to have proved this yet. We haven't had the opportunity to prove it yet. Our position is that evidence will show that Dominion and Transco agreed that the Zone 6 to Zone 6 rate would apply. And to answer Your Honor's question about why they nonetheless said there's no negotiated rate in light of the history of these contracts, some of the prior contracts, Your Honor, didn't just choose one of the many rates available under the tariff. They negotiated a different rate, a rate that didn't appear in the tariff. So the predecessor contract from 2014 for this very same stretch of transportation, 210 cooling plant to Fairless's facility, agreed on a rate of 16 cents. Now that rate didn't appear in the tariff. That wasn't choosing one tariff rate versus a different tariff rate. That was negotiating an entirely new rate. That rate, of course, had to be set forth on Exhibit C as a negotiated rate because otherwise the rate didn't exist, wasn't in the tariff. But here, our position is parties agreed that one of the tariff rates, Zone 6 to Zone 6 rate, which FERC has already decided is just and reasonable, would apply. That rate, by the way, is consistent with the parties that with our predecessor, Dominion, and Transco's course of dealing under these contracts going back many years, many iterations. And what's not consistent with that, and what doesn't make any sense under the circumstances of this contract, is saying that all of a sudden the contract rate doubled to the market link incremental rate, which is about 25 cents, from the 12-cent rate that applied for part of the time period, or the dramatic increase that we represented from 16 cents to that 25-cent rate. The parties never agreed to pay anything like 25 cents for this part of the pipeline. There are other parts of the pipeline, other parts of transportation at issue under other contracts where the parties agreed that the incremental market link rate would apply because those parts of the contract called for transportation over more of the market link stretch so that it was fair to pay more of the market link rate. But here, it's really anomalous. And again, we just don't have the firsthand knowledge because we weren't the party to the 2018 negotiations. It's really anomalous to think that Dominion agreed to double the rate from 12 to 25 cents or 13 to 25 cents. And even if you think of it as going up from 16 to 25, that's still a huge increase in the rate for absolutely no change. The same quantity of gas, same stretch of pipeline, all the same terms, nothing changed. Why would the rate double? Doesn't make sense. So that's why we think that if there were an evidentiary hearing and we had an opportunity for discovery, that we would be able to prove our claim that there is meeting of the minds by the parties on this rate. But we're not asking this court to hold that we're right about that. All we're asking for is a chance to be heard somewhere. We think that should have been in Texas state court. All of FERC's precedents support the idea that if it's a state law contract claim, and the claim is that there was a meeting of the minds between the parties under perhaps idiosyncratic negotiation conditions, that FERC has no interest in that. FERC has no expertise in that. That's an issue that FERC should leave to the Texas state courts. Endeavor.
Was this agreement filed with FERC?
The 2018, yes. All the FERC jurisdictional contracts get filed with FERC. That's right, Your Honor. But what I was going to say is all of FERC's precedents, and again, this is an APA review case, so FERC has to be affirmed, if at all, based on the reasons that it gave under Chenery. FERC's precedents, like Endeavor and BG and Northern Natural and Farmland and many others that we cite in our briefs, there's a whole line of them, say in general that FERC doesn't have any particular expertise in state law contract claims, doesn't have any particular need to resolve those issues. In BG, FERC made and Farmland, FERC made the good point that it actually can't definitively resolve those issues. If they're issues of state law, the state Supreme Court can definitively resolve them, not FERC. So why does it make sense for FERC to devote its resources to grabbing these issues out of the state courts where the state courts are perfectly competent to decide them? And Endeavor, I'm sorry, Your Honor, go ahead.
Generally dealt with these contract issues, like once these agreements are filed with it.
I'm sorry, Your Honor, I didn't hear the question.
Has FERC generally dealt with these contract issues once these agreements are filed with it?
I think that the most analogous case to try to answer that question is Endeavor. In Endeavor, the parties had a state law contract dispute, and then behind that, depending on the outcome of the state law contract dispute, there would have been a tariff interpretation question that might or might not have arisen, depending on the outcome of the state law contract claim. One party brought a state law case in state court, bringing that state law claim in state court. The other party went to FERC and said, you should grab this case under primary jurisdiction because there's a tariff interpretation question. FERC said, well, there may or may not be. There may or may not be a tariff interpretation question. It depends on what happens with the threshold state law question. So I'll just read the relevant line of paragraph 13 of Endeavor. FERC says, this argument only may become relevant after the contract has been interpreted. This issue will not become ripe until the ongoing state court proceeding is completed and may never become ripe at all. At this stage, no need exists for the commission to exercise jurisdiction. That was just as true here. Here we had a state law contract claim. We might succeed, we might not in state court. If we succeeded, then by definition, there was a contractual agreement on a rate, no issue about how to interpret the tariff, whatever arise. If we lost in state court, then that means that whatever the rate is under the tariff applies. Yes, FERC has an interest in that question, but that question wasn't presented yet, and it might never be, depending on the outcome of our state case. FERC didn't grapple with Endeavor because I think the reason is, just as this court said in Dynegy, it's not clear that FERC ever understood what our claim was. FERC persistently said that we didn't have a contract claim, that this was really just a dispute about how the tariff would be interpreted. That just assumes our claim away. And I think FERC's brief encapsulates this. The beginning of their summary of argument, and this is a fair summary of what FERC did below, is this rate dispute is a matter of tariff, not contract interpretation. On its face, the Fairless contract undisputedly does not specify a negotiated rate. Therefore, I'll come back to that, all parties agree that the rate for service under the contract is a recourse rate established in the tariff. Well, no, we don't agree. We don't agree that just because there's no negotiated rate on Exhibit C, that means that there can't be a contractual agreement on a rate. FERC is assuming that claim away. Therefore, in that quote that I just read, just doesn't follow. FERC is pretending that our claim is something other than it is and isn't grappling with the reality of our claim, just like in Dynegy. So it can't be sustainable under the APA for FERC to first exercise primary jurisdiction on the premise that there isn't really a state law contract claim here at all, when there is, and then to compound that error by refusing to actually adjudicate it. It'd be one thing if FERC had exercised primary jurisdiction, and we think that would have been wrong. But then if FERC had put itself in the shoes of the Texas court and said, okay, we're going to apply Texas law. We're going to put ourselves in the shoes of the Texas court. We're going to do what the Texas court would do. We're going to convene an evidentiary hearing. We're going to allow discovery. And we're going to decide this as if we're a Texas court. But FERC didn't do that. FERC assumed the claim away. And I want to point out what FERC said in its order here and just show how far it goes, how far it comes from sustaining what FERC did. We're really just talking about 3 paragraphs in FERC's rehearing order, 22, 23, and 24, where FERC gives its rationale. So in paragraph 22, FERC says that to determine whether to examine extrinsic evidence, you consider if the contract unambiguously addresses the issue. Well, that's true as far as it goes, but it ignores the concept of a latent ambiguity. And what's notable is that when FERC said that in paragraph 22, it didn't say anything about Texas law, didn't cite anything to do with Texas law, and it didn't cite anything having to do with any private contract under any state's law. Instead, it cited 3 cases having nothing to do with that situation at all. One was this court's decision in Transmission Agency of Northern California. What happened there was the California system operator asked FERC to approve consolidating 2 districts into 1 for pricing authority. FERC approved that, and someone challenged FERC's decision. Nothing to do with state law, nothing to do with private contracts. This court applied Chevron, not state law, in reviewing that decision by FERC. That has nothing to do with this case. And then FERC cited Southwest Power Pool, its own decision, where FERC interpreted not just a contract within its 4 corners, but a long history of FERC proceedings, settlements, tariffs, to determine whether there was a carve-out under a settlement that FERC had previously approved. There's no issue of state law, not a private contract case. And because the tariff was ambiguous, I mean, notably in that case, FERC looked not just to the 4 corners of the tariff, but it looked to the whole history of carve-out treatment in that matter. And in paragraph 20 of FERC's rehearing order in Southwest Power Pool, which again, FERC cites here in paragraph 22, FERC recognizes the concept of a latent ambiguity. It says a latent ambiguity often arises even where language is unambiguous on its face. Well, exactly. But FERC refused to do that here, and it perversely cited that very principle as a purported justification for not giving us a chance to be heard, not giving us a chance to flesh out our claim under Texas law. And then the third and last authority that FERC cited here for its decision is this court's decision in Missouri River affirming FERC's decision in Southwest Power Pool, where the argument there made to this court was that FERC erred by considering extrinsic evidence, that FERC should have just applied interpretive canons to the 4 corners and not looked beyond it. And this court said no, FERC was right to look at extrinsic evidence. Again, how that supports FERC's treatment of our Texas law claim here is completely beyond me. And then paragraph 24, the last paragraph of FERC's rehearing order, shows what FERC really thought, what FERC really was saying. FERC says there, I'm quoting, if the parties intended to apply a tariff rate that diverged from the applicable recourse rate under the tariff, then that understanding would need to have been expressly reflected in the Fairless contract as a negotiated rate, unquote. That's at J244. There's no cite for that proposition whatsoever. FERC cites nothing for it, nothing under Texas law, nothing under federal law, nothing. And what FERC is saying there in paragraph 24 is, it's either on Exhibit C or it can't exist. That's not right as a matter of Texas law, where the parties could have a meeting of the minds on a rate, but they didn't call a negotiated rate and didn't put on Exhibit C. They could still have a meeting of the minds as a matter of contract. And there's no federal law that would bar Texas from adopting that sort of a contractual principle. Now, I don't know, maybe FERC could convene a rulemaking proceeding and say, we're going to adopt a new rule prospectively that either it's on Exhibit C or it doesn't exist. I don't know if that would be valid or not. I don't know if FERC could do that. But I do know that FERC can't just announce this principle in paragraph 24, citing nothing, making it up, comes from nowhere, has no basis in anything, and have that be its decision for refusing to grapple with the reality of the claim that we brought.
So what is your best citation for the proposition that negotiated rate means only one of the alternative rates mentioned in Transco's tariff?
Your Honor, I don't have a cite for that proposition, and FERC doesn't have a cite in its order for any contrary proposition.
I know, but this is FERC's interpretation, having decided that the basic issue here is not state contract law, but rather what the tariff provides. And a premise of your argument, I thought, was that since Fairless was not choosing one of the listed alternative rates in the tariff, it necessarily had to answer the question, none. All right. But I didn't see you arguing that, and maybe I missed it, that in fact, FERC has already recognized this concept of latent ambiguity. And it decided there was none here, and that's the era of law. In other words, I'm trying to understand here, your client takes over somebody else's contract. It knows what the deal was with that other party. Now it's signing its own contract with Transco when it agrees to have this new agreement with Transco filed with FERC.
Your Honor, may I stop you there, because that's an important point and it's not factually accurate. Our client did not sign 2018 contract that's at issue here. That was Dominion signed that contract.
I understand that. And that's critical here. All right, I understand that. But I'm trying to get you to acknowledge what Fairless did vis-a-vis Transco's tariff.
Well, so Your Honor, let me try to answer your question in a couple of different ways. Fairless itself didn't do anything vis-a-vis Transco in terms of the tariff. Fairless bought this contract from Dominion. So, but I also wanted to respond to what Your Honor said a minute ago about latent ambiguity and what FERC said in
I need you to address my next point. My premise of my question is not that Fairless didn't buy the contract from Dominion, but then, and this is what you need to address, did not Fairless agree to this tariff that was filed with the commission, where it stated that there was no alternative rate? That's what I'm trying to understand.
So I'm not sure what Your Honor is referring to, and referring to Fairless agreeing to a rate filed in the tariff. I mean, I suppose Fairless could have filed some sort of a...
Come on, you heard my question. I asked you whether the tariff language was referring only to a rate that was not one of the alternative rates mentioned in the tariff itself, but rather was something that the parties had previously negotiated, and it wanted to apply, to continue to apply as to the tariff that was being filed, showing it had taken over Dominion's contract.
Your Honor, let me try to answer your question. I really am trying. There's a lot of things going on in your question. So first,
I'm trying to make it simple because I understand your responses, but I think you're sliding over this one point I'm trying to understand, and maybe I am misunderstanding the point, but I need to be clear about it.
So I think I heard Your Honor say a moment ago that what we're arguing is that Fairless is arguing that the parties here in the 2018 contract at issue agreed on a rate that isn't in the tariff. That's not, if I heard that correctly, that's not correct. In a prior contract, and this is what I was addressing a few moments ago in response to a different question by Your Honor, in a prior contract, not at issue directly here, the parties, Dominion and Transco, agreed on a specific rate of 16 cents. That rate was set forth on Exhibit C as a negotiated rate because it had to be. 16 cents wasn't a tariff rate. It wasn't one or another of the rates set out in the tariff. It was a separately negotiated rate that as such had to be set out on Exhibit C or else it just didn't exist. That's not what is at issue here. Our claim here is not that there is a negotiated rate that isn't in the tariff that the parties agreed on. That's not our claim. Our claim is there are a lot of different rates in the tariff. Parties can agree on one or another of those tariff rates. They're all just and reasonable. They've all been approved by FERC. And here our claim is the parties agreed on the Zone 6 to Zone 6 tariff rate as opposed to some other tariff rate.
Well, why wouldn't that have been indicated? That's what I'm trying to understand, where the contract, when the tariff was filed, why wouldn't that have been indicated?
Well, Your Honor, obviously this would be clearer and we would be better off if Dominion had on Exhibit C noted what our position is. But again, our position under Texas law, and I can't answer exactly what happened in 2018 because our client wasn't involved in those discussions. Our client came in later.
The implication here that Transco acted sua sponte without Fairless's knowledge?
Well, Transco didn't act sua sponte in agreeing to this contract in 2018 with Dominion, but again, Fairless wasn't in the picture yet.
Fairless.
I guess I'm not sure what Your Honor means by acting sua sponte. I mean, when Fairless bought the contract,
file an agreement in a tariff that was filed with FERC that said Fairless was now stepping in to Dominion's shoes, basically.
Your Honor, I don't know anything one way or the other about that. I don't know how to answer Your Honor's question. I don't know factually what occurred. I am assuming just because
as a matter of law, did Transco have the authority? Is that part of your response?
No, I don't think it is. I mean, my understanding is that the pipeline, which has the tariff on file with FERC, would need to file with FERC contracts, so that those contracts are available with FERC. I assume that Transco did that. I don't know one way or the other, as a matter of fact, what, if any, involvement Fairless had in that. So that's what I'm saying. I just don't know how to answer that question, Your Honor. I don't know the facts. But I think here,
come under the latent ambiguity doctrine. But what's latent about this is what I'm trying to understand.
What's latent is how the language in the contract applies to the unique circumstances of these parties and their negotiations in 2018.
With whom?
Between Dominion and Transco. Those were the parties that negotiated.
Right. So now we're talking about Fairless and Transco and the tariff filed there.
But I don't think anyone disputes that if we're right that Dominion and Transco agree that the Zone 6 to Zone 6 rate would apply, that Fairless gets the benefit of that agreement. Fairless inherited this contract. So I think the question again is just, what did Dominion and Fairless agree to as a matter of contract? Did they agree on a contractual rate, or did they just punt and say whatever rate applies under the tariff is what applies? And FERC
No,
gets
counsel, what I'm getting at, and you probably know more about this than I do, if I'm out in the private market, and I buy out your interest in an operation, I'm not clear that I would automatically get the benefit of any negotiated rate that you may have obtained. I'm buying your interest, and so I have to indicate clearly what I want to do in this new situation. That's the way I understand FERC to argue, and maybe FERC can clarify for me. But that's what I'm having difficulty understanding, where FERC says this is primarily a matter of a tariff interpretation, not state contract law. And so it says, look at the four corners of the tariff, end of discussion. And you say, no, that's wrong, because I don't know what you call it, but there was some kind of agreement with Transco and Fairless that it too would have a negotiated rate.
Your Honor, we're not arguing that Fairless itself, as opposed to by operation of law inheriting a contract from Dominion, we're not arguing that Fairless itself negotiated an agreement on a rate with Transco. We're arguing that Dominion did, and that Fairless inherits that contract, steps in Dominion's shoes, and gets whatever the rate is under that contract.
And what I tried to do with my hypothetical, whereas I buy your interest in a corporation, there's a proposition of law that I'm not hearing here, that if I buy your interest, suppose you own 51% of the shares in a building. Am I, as a matter of law, entitled to any special arrangements that you've made? Or do I have to negotiate my own contract with, the other shareholders or the owner of the company? That's all I'm trying to understand here.
I understand, and I guess maybe the simplest answer is that's just not what happened here. This isn't about acquiring a majority interest in a corporation and maybe the assets and the liabilities go to different places. That's not what happened here. This is just a contract that Dominion had, that Dominion sold to Fairless, and that as a matter of FERC law, and I think Your Honor asked a few minutes ago what FERC's position is, and I don't want to speak for FERC, but certainly there's no suggestion in any of the FERC decisions below that Fairless doesn't stand in Dominion's position. Let me take out the double negatives there. As far as I know,
I get your
everyone here agrees, that if Dominion and Transco agreed that the 6-to-6 rate would apply, which is our position, that's what happened, that we, Fairless, get the benefit of that because it's the same contract. We just inherited it. I don't think there's any dispute about that. The dispute is who decides, right? Does the Texas court get to decide whether we're right that there was such a contractual agreement, or does FERC get to decide? And if FERC gets to decide, did FERC actually decide? Did FERC actually grapple with the claim that we brought and decide it, putting itself in the shoes of the Texas court, applying Texas law? Our position is no. If you look at what FERC actually said, FERC didn't cite any Texas law, didn't say anything about Texas law. And in fact, it cited only the 3 cases I mentioned before, which have nothing to do with private contracts or state law at all. And in fact, in one of those cases, it actually exemplifies how FERC recognizes that it does sometimes have to look beyond the 4 corners of a document because of latent ambiguity, which is what FERC should have done here, but refused to do because FERC maybe never understood the reality of the claim that we were bringing, just as in Dynegy. And as a matter of basic APA principles, the court can't sustain an agency's decision if the agency didn't understand the claim that it was adjudicating. If the agency misunderstood what was before it, then it can't have issued a decision that was not arbitrary and capricious or an abuse of discretion, the basic principle of APA review is the agency has to actually understand and grapple with the arguments that are made. There's hundreds of cases by this court that I could cite for that proposition. A few of them are in our brief. Dynegy may be the most on point because it involves FERC. Just as here, there the court said, not clear that FERC ever really understood what the petitioner was arguing. And here, if FERC did understand that we had a state law claim that there was an agreement on a rate, notwithstanding the fact that it's not a negotiated rate on Exhibit C, if FERC did understand that, then FERC improperly swept that under the rug and it never really grappled with that issue, which is why I think FERC actually just didn't understand that. Why this case at the very least needs to be remanded to FERC for FERC to grapple with what it didn't grapple with adequately first time around. What we really think should happen is this case should go back to the Texas State Court, just as in Andeavor, just as in BG, just as in ARCLA itself, where FERC set out the factors governing primary jurisdiction, where FERC says, in general, on state law issues, we don't have any particular expertise. We don't have any particular dog in the fight about state law issues. As long as the rate under state law, one way or the other, whichever rate it is going to be just and reasonable, which both of these are, then it's really not FERC's concern. And it's an idiosyncratic, here, potentially just really genuinely sui generis issue about what these parties in 2018 agreed to. That really isn't any concern of FERC's as long as what they agreed to is otherwise just reasonable, which no one here disputes that it is. So we think.
Thank you. Thank you, counsel. And thank you, Judge Charles, for letting me try to clarify this.
Thank you very much, Your Honors.
Morning, Carol Banson for the Commission. Judge Rogers, I will address some of the confusion and some of the questions that you were asking, but I have to begin by correcting something. It is entirely incorrect to say that all of the tariff rates would be just and reasonable as to Fairless, because these are tariff recourse rates, meaning that it's what's there if there is no negotiated rate, and we will get to discussing why there isn't one in the contract when we look at it, and why this is in fact a case of tariff interpretation. Recourse rates are not something that parties agree to. You can state it as a negotiated rate, as these same parties explicitly did in 2006 and 2014 in what we call the 2014 other contract. They actually did agree to give the equivalent of the Zone 6 system rate, and they stated it as a negotiated rate in Exhibit C, where it said the negotiated rate that is the equivalent of Zone 6, setting aside a negotiated rate stated in Exhibit C. A tariff recourse rate is a specific rate that the Commission has approved as just and reasonable for a particular service. It is a cost-based rate. It's based on cost of service plus a particular profit margin. In this case, so there are 32 incremental rates for various expansions on Transco's system in its tariff. And there's the general system rate. And it is true that the Commission has approved every one of those rates as a just and reasonable cost-based rate. But it's only just and reasonable as to the service, the costs of which it considered when it approved it. So, for instance, the general system rate is made up of the costs of the whole system, upgrades, and it's the mainline system that may be quite old. Parts of it may have been upgraded. Since the 1999 certificate policy statement that we cited, the Commission said, with regard to expansions, for purposes of correct price signaling and also avoiding subsidization and surprise rate changes for existing customers of the mainline system, we will insist that expansions be paid for by expansion customers. So when we look at the orders that we cited for this particular expansion that was approved in 1999 and then amended in 2000, in the amending order in 2000, that's when Virginia Marketing first comes into the picture. They're a precedent shipper on this new to-be-built expansion. They dominated phase 2 of the expansion. They had 100,000 decatherms per day of the 130 on that part. So Transco was building this expansion, and it was justifying the need to build the expansion to the Commission based on the fact that it had these two customers, one of which was Virginia Marketing. And the Commission said, that's fine, those are your precedent shippers, your recourse rates have to be based on the cost of that expansion. And those recourse rates will be allocated to the customers of that expansion and not on everyone else. Transco is free, although not obligated, to negotiate rates with its shippers. A pipeline often finds it in its interest to do. It's trying to attract new shippers to an expansion that it wants to build. So maybe it does negotiate a rate that's lower than the cost-based rate that it can justify to the commission. But the cost-based rate is there in the tariff as what's there when there's no negotiated rate, or when a negotiated rate expires, which is what happened in the 2014 predecessor agreement. There was a negotiated rate that expired in November 2018. And then in December 2018, there's the Fairless contract that says none. So from the expiration on November 1st, it was back to the recourse rate because there was no negotiated rate as of that date. And then there was no negotiated rate in the new contract either. But the expansion rate was based on the costs of building and operating the market link expansion. And that recourse rate is what the commission found just and reasonable to be the rate for those expansion customers. It has never, and it explicitly said this in footnote 92 in the declaratory order, it has never found that it's just and reasonable for the market link shippers to pay the general system rate. So no, we do not agree that all rates are just and reasonable as to every party. The tariff is not a choose your own recourse rate menu. If you cannot reach an agreement with the pipeline, the recourse rate you pay is the specific rate for the service that you have. And that's the analysis that the commission did in these orders. What service do you have? And it started with that history of when Virginia Marketing committed the capacity, the 100,000 decatherms per day of capacity to serve a plant. The Fairless plant hadn't been built yet. It was coming online in 2004. And as we cited in our brief, Fairless has repeatedly acknowledged that Transco's existing system could not have served it with the amount of fuel that it needed for its plant. The reason Virginia Marketing signed on for the market link expansion was because it needed to serve this new plant that it was building, and the existing Transco system did not have that capacity available to serve them. So
let's talk a little bit about the jurisdiction, though. I mean, what factors would the commission use when it's looking to determine whether it's going to rule on a contract dispute?
And that ties in the commission's holding to what recourse rates are and what they mean was its key. And when it cited it for uniformity, it said in the rehearing order that it could have invoked its primary jurisdiction based entirely solely on the uniformity, because it's very important. There are other shippers on the market link expansions. There are other shippers on the 31 other expansion incremental rates that Transco also has. And there are numerous pipelines around the country that have expansion incremental rates and general system rates. So as a matter of tariff interpretation, if we have a case where one particular party says, well, I don't like the incremental rate, I think I should get the general system rate, even though you've never approved the general system rate for market link shippers, I think I should have it. If that were to prevail, if that view were to prevail, then what stops all the other expansion shippers, both on Transco's pipeline and any other pipeline, from going to court to say, yeah, we don't like our incremental rates either. We'd really like the general system rate. We think it's lower. And you should just give it to that because we agreed to it, even though we didn't state it as a negotiated rate. So the commission found it important as a matter of what tariffs mean and what we're even doing when we approve these rates as just and reasonable, and when we want to guard against subsidization, when we want to, if the pipeline can't recover its costs for the expansion from its shippers, then I mean, we approved it to enable them to recover its costs, and we also stand by not allowing the pipeline to get those costs from the other customers to subsidize the expansion because the expansion customers didn't pay for it.
But what do we rely on as precedent for the primary jurisdiction for that proposition about consistency, review of contracts here, versus this being what the Fairless would consider a tariff issue as opposed to not a tariff issue, but a true contract dispute? Well,
United Illuminating, certainly the key case that the commission cited. In that one, now the commission, after invoking primary jurisdiction, did find there was an ambiguity in that contract and set it for hearing. But the commission isn't citing that here for ambiguity versus four corners of the contract. It's citing it for the importance of its primary jurisdiction. So we had several cases that we cited. I think Northern Natural Gas is the commission rejected an argument that the case was about a contract rather than a tariff interpretation, and found that it was important for a tariff interpretation to invoke primary jurisdiction. United Illuminating in particular is important also because it goes to the expertise, which was another thing that the commission cited. We're not going to argue that the idea of recourse rates is a simple concept. And recourse versus negotiated rates, incremental expansion rates versus general system rates. This is the bread and butter of FERC. It's not necessarily the bread and butter of state courts. So as a matter, it's very similar to in United Illuminating. The court was, or the commission was dealing with reliability must run agreements, ISO reliability charges, the kind of thing that the commission had approved these charges to begin with. And that also goes to the third prong of the regulatory responsibility. In United Illuminating, the commission said, because we have approved these reliability charges to be recovered, we have an interest in this dispute to make sure they are in fact recovered. And that goes back to what I was saying about incremental expansion rates, that the commission, having set out a policy decades ago that incremental expansion shippers should pay for expansion facilities with incremental rates that cover the costs of those facilities, having made that as a policy and said that those will not be subsidized by general system customers, the commission has an interest in making sure that there is a distinction between which rate you pay, and that you don't just get to say, outside the context of a specific negotiated rate, of course, you don't just get to say, we want that recourse rate because we like that one better, even though it has nothing to do with the facilities we're being served on, and we've been expansion shippers all along, but we'd rather have that rate. That is not how recourse rates work, and that's why the commission invoked its primary jurisdiction. To this date, I don't think the petitioner has ever cited a case where a court reviewed or let alone overturned that. We're not saying it's non-reviewable. We never argued that, but the discretion is broad and the bar is high.
But you believe this is beyond a typical contract dispute?
It is a tariff. It is a tariff dispute, and I'd like to go to the contract to really highlight that. Mm-hmm. Now, this contract is a form agreement that Transco uses that the commission has approved for that purpose. So this is not a unique contract that the commission has never seen. But in this world where there are two kinds of rates that you can pay, and I do want to get a case set up because it also goes to another point. I want to make sure that I highlight Iberdrola Renewables from this court in 2010 talks a lot about negotiated rates versus recourse rates. It also has a successor to a contract that didn't like the deal that their predecessor made. It did not matter. This court talks a great deal in that about negotiated rates. And it's a very helpful case just for the whole context. But
what's the right?
Iberdrola Renewables is 597F third. I don't know the
That's good enough.
The particular part about the successor is at 1305, but the case starts at 1299. But looking at J76, which is this contract, although the same language is in nearly all of these contracts, and looking at Article 5, Section 1. So we have the first sentence that says, buyer shall pay seller in accordance with seller's rate schedule FT. That means if you don't say anything else, what's the tariff say? What's the recourse rate? And that's why the commission would look at that as a tariff interpretation. It goes on at the end and says, if the buyer and seller mutually agree to a negotiated rate, provisions governing such negotiated rate and term shall be set forth on Exhibit C. I don't think petitioner has ever addressed what the meaning of shall. We understand it to be mandatory. If there's a negotiated rate, you say it on Exhibit C. I don't think I've ever heard this argument that you only have to use Exhibit C if you're picking some rate like 30 cents, but it's patently just proven by what they did themselves in the 2006 and the 2014 other contracts where on Exhibit C, they did pick a rate from the tariff. They weren't entitled to that rate as a recourse rate, so they got it as a negotiated rate. And so on J90, which is the 2014 other contract, Fairless's other contract got a negotiated base reservation rate and commodity equal to sellers' generally applicable Zone 6 to Zone 6 daily reservation commodity rate. So they don't get it as a matter of recourse under rate schedule FT, but if they can agree to it mutually between the parties and stated on Exhibit C, they've shown that they can actually pluck a number from the tariff. But absent that agreement that shall be stated on Exhibit C, and they didn't leave Exhibit C blank, they said none. Absent that, it's a tariff case and not a contract case, because you don't just get to decide which recourse rate you like better. And if the parties...
So going back to a question Judge Childs asked at the very beginning, were FERC to be affirmed here, then is there no recourse for Fairless to prove what's being tossed around here is a latent ambiguity?
Well, I would like
in the state court, in other words, where FERC refers this question to the state court. The state court, let's just hypothetically say, rules in Fairless's favor that there was a negotiated rate. Then does Fairless have to wait until the term of the current tariff expires, or can it renegotiate?
Well, it could always try to renegotiate, but it would be bound by its contract. Let me say a couple of things about latent ambiguity. I did a word search and I see no mention of it in the rehearing request. The commission never
cited at page 24 in rehearing. At any rate, of the rehearing order. Any event, I just want to be clear as to what your understanding of the law is here.
The law is, in the world of pipeline rates, the pipeline is authorized to negotiate rates. It has, and that would be memorialized in the agreement. This agreement says if you negotiate a rate, you set it forth in this contract.
And suppose you didn't. Then you're just stuck with
the tariff.
The tariff for the term of the tariff.
Yes, but that's what
unless FERC would agree to rehearing.
I don't know what FERC would agree to a rehearing on. I mean, the recourse rates are recourse rates.
Well, it would say there was this latent ambiguity. We thought, you know, we didn't have to fill in Exhibit C the way we needed to. But
first of all, I mean,
FERC would have discretion as to whether it grants rehearing, but I just want to be sure. So once you're stuck, and then whatever the term of the tariff is, you have to wait until you get a chance to enter into a new agreement with.
Yeah, I can't agree with the characterization of stuck. It is the recourse rate, and it always was the recourse rate. And again, I would point to Iberdrola Renewables. Yeah, I mean, this court said in Iberdrola Renewables that when you enter a contract, you are bound by the terms of that contract.
No question, counsel, but you know, I just want to understand: is it different in tariff law than it is in general contract law? The other party may not want to renegotiate, but it doesn't mean it's barred from renegotiating.
No, they can renegotiate the contract. The tariff is not negotiated. The tariff is proposed by the tariff rate is proposed and then justified by the pipeline, and the commission determines based on a showing of cost of service. It decides what the recourse rate is as a cost-based rate, not a negotiated rate. So what the commission believes that, I mean, on its face, Article 5 says, if you want to negotiate a rate, fine, it shall be stated in this contract. When it says that a buyer shall pay seller in accordance with seller's rate schedule FT, that means you shall pay in accordance with the tariff. The tariff is a matter of tariff interpretation that the commission gets Chevron deference in interpreting the tariff that it approved. But the tariff is not something that any parties negotiated and submitted. Transco had to come in to the commission when it came in, when it was actually looking for certificate approval to build the pipeline. It had to propose its rates. It had to substantiate those rates. It had to show its costs. The commission had to look at that and say, these cost of service rates are just and reasonable under Natural Gas Act Section 4. I should correct myself. There is one other recourse that Fairless or any other party could have. Any party that believes that a rate under the tariff is unjust and unreasonable or unduly discriminatory or preferential can bring a complaint under Natural Gas Act Section 5. There are two ways to change the tariff. The pipeline can propose its own change under Section 4, subject to finding it's just and reasonable. Any other party or the commission itself could initiate a proceeding to potentially find that rate unjust and unreasonable and then replace it with a just and reasonable rate. So they are not, in fact, without recourse. They have the same recourse any other party under a tariff has of challenging that rate pursuant to Section 5. That has been no part of this case. That has not happened.
No. But yes, all right. But I thought Section 5 was more limited than would embrace what Fairless is arguing here. But maybe I'm wrong about.
I might not be able to make the showing, but I'm just saying that a party with a long-term contract that is not happy with the recourse rate would have, if they could make the necessary showing, they're not without that avenue. I want to hear about that.
But does Fairless's latent ambiguity claim lose strength based on its payment of the market link rate?
They're trying to argue that there's a latent ambiguity in what the reference to the tariff means. And I've just never seen anything like it. It's a tariff. It's a tariff rate that the commission approved. It's the recourse rate if you don't have a negotiated rate. There's nothing ambiguous about what the contract says. The contract says the tariff rules. If there is any ambiguity about which price in the tariff applies, that's a straight up question of tariff interpretation that the commission gets deference for. And the commission went through it in this order, looking at what facilities service. It looked at the history of the fact that this all started with service to Fairless that could not be provided under the existing system. So Virginia Marketing was a market link shipper. Every filing that Transco has made across the time has continued, because it's never had authority to charge a different recourse rate. It has authority to negotiate a different rate, but it doesn't have authority to change that recourse rate itself. It has to make a showing to the commission that no one has ever proposed. So the commission looked at Fairless's admissions that it does, Station 210 is part of the market link expansion, so it is served from market link facilities. It always was served from the market link expansion. And the commission looked at the orders that approve the market link expansion, including the precedent agreement with Virginia Marketing. And it has more than a scintilla of substantial evidence, which is what the commission would need to be affirmed on its finding under the contract. I'd say it's much more than a scintilla, but it certainly meets the substantial evidence standard in the Natural Gas Act.
And so the argument that, well, Dominion's special rate, negotiated rate expired in 2018, absent Fairless indicating something to the contrary, it was going to be stuck with the rate on these expansion facilities.
Which it's still being served by. But I mean, it certainly could renegotiate if Transco were open to it. And it did, negotiate that contract in 2018. What I would say is, I'm sorry, I lost that thought. But
so under the commission's view, the latent ambiguity exception, if I can put it that way, does not apply.
Right. I mean, again, since the commission didn't see that issue raised, so it didn't address that explicitly, but the commission does understand that the reference in the first sentence of that Article 5 in the contract says buyer shall pay seller in accordance with the tariff, unless you state the negotiated rate in Exhibit C. So Exhibit C on its face says none. Article 5 on its face says it shall be there if it exists, and it doesn't because it says none. So all Article 5 says is buyer shall pay seller the tariff rate. And then we're in
okay. So when Transco files the tariff with the commission, has Fairless seen it in advance?
Well, the tariff these rates were added in the orders in 2000. Or the tariff is publicly available. I think it's online. I forget whether it's.
Okay, so Fairless could have reviewed it.
Oh, sure.
What I'm trying to get at is at what point does Fairless have a chance to raise this point? And I get your point about, well, they just simply misread the contract. They misunderstood the history of events here, the plain terms of the contract, and what FERC was doing with expansion facilities.
I think there are maybe two more direct answers to your question about what Fairless could have done or could do. And it goes to the same bifurcation between whether you have a negotiated contract rate or a tariff recourse rate. You either reach an agreement with Transco, and Transco's counsel, I think, may speak to this, but there may be some evidence in the record that Transco isn't obligated to agree to a negotiated rate. It had for a long time. Maybe it could in the future. It certainly has the right to, but it doesn't have to. You can try to renegotiate with Transco, or if you think you can meet the burden under Natural Gas Act Section 5, you can challenge the tariff rate. So those are your recourses under the contract. Either have negotiated the contract rate, or now that you haven't, you're in the tariff world and your recourse, I don't want to confuse the term recourse. Your avenue is Natural Gas Act Section 5.
Thank you.
Thank you.
All right.
Good afternoon, Your Honor, and may it please the court, Matt Bennett for Transco. I'd like to start with the very last question that was asked about whether Fairless has notice of these rates and rate changes. They do. Whenever the market link rate or any other rate in the tariff is changed, it has to be filed at FERC before the change takes effect, and it is public noticed, and people have the opportunity to intervene, protest, comment, do whatever they will. In addition, whenever Transco negotiates a rate with an individual customer, Transco files a rate sheet in its tariff, section 13 of the tariff, that specifies that rate sheet. The rate sheets at issue here, in this case, were filed in 2014 for the 2014 contract. And in those rate sheets, they actually specified the rate schedule FT market link as the rate that was applicable to this service, but for the negotiated rates that they negotiated at the time. One of those rates in the contracted issue here expired in November 2018. The parties did not renegotiate, and when they signed a new agreement, they reflected none, which, as Judge Rogers pointed out, is pretty unambiguous. In fact, it is unambiguous. A rate that is a negotiated rate is one that has to be specified in Exhibit C in order to be effective, and that's per Article 5 of the contract, as Ms. Banta acknowledged. Fairless would have you believe that, notwithstanding placing the word none in the contract, that they actually, Fairless and Transco, had agreed to some other unspecified rate, but for some reason did not put it in the contract, which is actually contrary to the other contract, the other 2018 contract that specified the Zone 6 to Zone 6 rate as the applicable negotiated rate for that tranche of service. And one other point I'd like to make is, as Ms. Banta alluded to, these negotiated rates are often negotiated at the outset when a pipeline is building an expansion to attract shippers to that expansion. Those rates do tend to be time limited. The initial negotiated rate in this case was time limited to 10 years. Transco was willing to renegotiate that with the shipper, first Virginia Power and Energy Marketing, and later with Dominion Energy Fairless over time. But Transco has never agreed to a negotiated rate for any of this pipeline expansion service in perpetuity. And I will just note that over time, as the Market Link project has been in service, when it was first placed in service, most of the agreements were with negotiated rates. And since over the course of time, that has actually flipped, and now most shippers on the market link pipeline are actually paying the recourse rate in the tariff and not a negotiated rate. One last point I would like to make, just to reinforce, I don't want to repeat or tread on old ground, but Fairless's theory of this case is that the tariff is a menu, and you can pick and choose whichever rate you want. That is not the case. When FERC approved the market link project, they specifically approved it at a recourse rate based on the incremental cost of service of that specific facility, or parties could negotiate an alternative rate. In this case, that's what happened. The parties negotiated an alternative rate that was in effect for a certain amount of time and then has since expired. And so the default is to the recourse rate that is set forth in the tariff. I'm out of time and happy to entertain any questions that the court has.
Nothing here. Judge Rogers?
Nothing from me, thank you.
Thank you for your time. I appreciate it.
Thank you.
I'll be very brief, 4 quick points. First, most of what we heard from my friend Ms. Banta is about why, in the absence of a contractual agreement or rate, the rate that would apply to the 210 pooling plant, to to Fairless's facility under the tariff, in the absence of a contractual agreement, is the market link rate. We're not disputing that. I want to be clear about that. I think we've been clear about that, but I want to be totally clear about that. We're not disputing that. The question is, was there a contractual agreement, which I think everyone agrees would trump whatever would otherwise apply under the tariff. That's the point of a contractual agreement. So, and I think then the next thing I wanted to say about that is I may have been careless in the way I phrased something earlier when I said that every rate in the tariff is just and reasonable. That's true in the abstract. Ms. Banta is right that it doesn't necessarily mean that every rate in the tariff is just and reasonable as applied to any particular set of facts. But that doesn't matter. What matters is there's no dispute that both rates at issue here, the one we say applies, 6 to 6, and the one they say applies, are just and reasonable as applied to the transportation of gas covered by this contract. In fact, the 6 by 6 rate is what applied to the very same transportation of the very same quantity of gas from the very same point to the very same point for a long time, with not a hint of suggestion from FERC that somehow that wasn't just and reasonable. So to be more precise than I was earlier, there's no dispute that the rate we're advocating here under the contract would be just and reasonable. That's why it's particularly galling to us for FERC to have gone out of its way to take this issue out of the state court and decide it itself, because FERC shouldn't care, really, whether one of two equally just and reasonable rates applies to this particular contract under sui generis conditions about contractual negotiations. My friend relied on United Illuminating at the podium, and FERC relied on it in its initial decision, although not the rehearing order. Here, I think it's worth talking for a moment about United Illuminating. That's a case where FERC said, yes, it's kind of a contract issue, but we're going to exercise primary jurisdiction because it's a really technical contract issue. It requires interpreting terms like, quote, transmission congestion costs, unquote, and, quote, reliability must run, unquote. Nothing like that here. There's no technical aspects of this contract. It's simply what the parties in 2018 intended, whether they had a meeting of the minds or not. And if so, what was it? There's nothing technical about that, and FERC has no particular insight into that. That's what FERC has recognized in case after case after case involving state law claims. The other thing that's particularly interesting about United Illuminating, why it's especially galling for FERC to be relying on it as a ground for its decision here, is there, as my friend acknowledged, FERC found that the contract was ambiguous. And it applied New York law, recognizing that there could be such a thing as ambiguity, or that there could be a need to take evidence. And it referred the case to an ALJ, and the ALJ granted discovery and held an evidentiary hearing and ultimately found that the parties had a meeting of the minds. That's the ALJ's language in paragraph 119 of the initial decision on the issue that was in dispute. And then FERC approved that initial decision by the ALJ. That's what should have occurred here. If FERC really thought that the possibility that depending on the outcome of the contract issue, that FERC might have to construe the tariff, that possibility was so important and the construction of the tariff was so important to FERC's regulatory responsibilities that FERC would take this case from the state court, then FERC should have done what it did in United Illuminating, instead of sweeping under the rug our state law claim. One other point, Your Honor, Judge Childs, you asked whether, I hope I'm getting this right, whether our claim that there was latent ambiguity would lose strength because we paid the market link. We never paid the market link rate under this contract without immediately and clearly protesting. As soon as Fairless inherited this contract, the very first time that we were billed under it by Transco, we were billed for the market link rate. We said, hold on, what gives? We thought it was the 6x6 rate, and we protested. We had to pay under protest because that's how it works in FERC world, but we always protested. And the final point is that a lot of what we heard from my friend Ms. Banta is that Exhibit C says none, and therefore this is a simple case. And so I acknowledge the fact that Exhibit C says none means that we might not succeed on our state law claim that there was nonetheless a contractual agreement on a rate. But that isn't a reason to pretend that that claim is not a state law claim. It isn't a reason to pretend that we aren't claiming that there was nonetheless a contractual agreement on a rate. If we succeed on that claim, that's because of the intent of these parties in 2018 under sui generis contract conditions in a way that where the result would be the application of a rate that applied for many years to the same contract in a way that shouldn't bore any ox of FERC's, that FERC shouldn't have any concern about. And if somehow that did have any concern for FERC, then FERC could do what it did in Endeavor and say, well, the initial question is one of state law. We don't really have an interest in that. We don't really have expertise in that. But depending on the outcome of that, there could be a tariff interpretation issue that would arise. You all know where to find us. Come find us at that point if you need to. There's no reason why FERC couldn't have done that here. And at the very least, if FERC was determined to take this case from the Texas courts, FERC had to put itself in the shoes of the Texas court and give us a fair hearing, had to actually adjudicate our Texas law claim, not pretend that it didn't exist. Thank you very much, Your Honors. I appreciate your indulgence at the time, both of you. Thank you very much.
Thank you very much. That will conclude this hearing, and we will take it under advisement.